Hello, good evening, class.
Good evening.
Oh, how you doing?
Hi, Mr. Julio.
Oh, hi, how you doing, Tatiana? How's everything?
Good.
Well,
How
I
was your
hope
weekend?
good. I hope you guys enjoy your long weekend.
Yeah, I turned 30 yesterday.
Ah, okay. Listen, we're gonna get there. Well, some of us already passed that long time ago. So no worries. It's part of life. As long as you enjoy it, that's the most important thing. Okay. I thought my students were going to be right there at the time of uh, the class, but still they are on vacation, I guess. Still having a break. But that's fine. I think that they're going to start joining it eventually. Okay. Before we start the class, do you guys have any questions about anything that we have covered?
For me, not right now.
Okay, good. Remember, feel free. Send me an email if you have something. If there is something private, do not discuss it in the class. Just send me an email and I will be more than glad to answer your questions, okay? Okay, so we're going to continue with medical law and ethics. This is a chapter where we are going to talk about liability and medical malpractice. Probably you heard a lot about malpractice. Yes, we're going to know what is the definition of malpractice, what exactly liability means. But we're going to talk about liability in the professional setting. So liability means that you are responsible for whatever you do, any acts that you do, any issues that you go through, and you're responsible for those. So that's basically what it is. Medical assistants are liable in the workplace, not just the doctors. Everyone who works in the medical field is liable, responsible for all the tasks and whatever goes on within the medical, within the time that they are working. So that's basically what it is. So let's try to put all these terms together, because sometimes some of them can be used interchangeably, but in some other cases, no, they are similar, but they are not the same. So that's basically what it is. So let's start right here. So we are going to talk about negligence in malpractice. Now, negligence, malpractice can happen in any field, in any industry. Negligence. You are neglecting to do something that you know you have to do, but you're not doing it. So that is negligence. When you're being trained to do something, you were prepared to do something, but you didn't do it or you didn't do it right. So usually it's unintentional. Not that you wanted to, it's just that you were careless, so to speak. So medical negligence. Remember, negligence applies across the board. You can be negligent with your kids. You're not taking care of them. You know that is your obligation. They are your kids, whether it's the father or the mother, not only making responsible the mother. No, who's the father? Who made those kids? Well, he is responsible for those kids. He's supposed to support them, not financially, emotionally. You have to be there, the same the mother. But if you disregard your obligations, not that you want to do it intentionally, You think, oh, well, they probably don't need me to be there all the time. Oh, I think that they're not gonna die if they don't eat 1 day or 2 days, or if they are cold, or if they don't go to the school, don't get an education. That is fine. So many kids are out there that they don't do much. Well, mines are not different. Well, you are being negligent. In the medical field, means that you did not apply all the training that you learned. You're not using it. You just didn't care. Or you just went beyond or below what you were supposed to be doing. That is malpractice. See, those things kind of, these two terms sounds like the same, but actually it is differences. So let's talk about malpractice now. So you heard about the word malpractice, you heard about the word negligence. Now we are going to find the differences. So both of them are wrongdoings. You're doing something wrong. Yes, things are not going well with your patient. Let's go back to the medical setting because this is medical malpractice in professional negligence in your workplace. So they are similar because you're doing something wrong, but the difference is how you're doing it wrong. Malpractice. This is something that you were not trained to do. You're not a surgical doctor, but you're performing surgery on a patient. Yes, you're a medical doctor, but not every single medical doctor is a surgical doctor. I'm an emergency medical doctor. So I cannot go and do psychiatry. I cannot go and work as a plastic surgeon or not even a regular surgical doctor. I'm not. I wasn't trained for that. Now, if I'm not trained to do something, what do you think the outcome of what my doings are going to come out? That will be wrong because I'm not trained to do so. I don't know how that works. So if I put myself in that situation, I'm going to do something wrong. Let me give you an example, very simple sample. Your parents have a car. You don't have a driver license. Pay attention to this. But on top of that, you don't know how to drive. But you take your parents' car, you get into an accident. Well, already it's a wrongdoing, just the fact that you took the car. You shouldn't be doing it without your parents' permission. Number one, it's a wrongdoing. Now, it makes it worse because you committed a violation outside. You got into an accident. You passed the red light. Now you're going to be sued. You're going to be given a summon, a ticket. Now you have to pay, or your parents going to have to pay. So you see, here you are not doing the right thing. First of all, because you weren't trained to do so. So many people get in trouble because they do things that they are not supposed to be doing. And that's what I keep on telling you all the time. If you're a medical doctor, the nurse asks you to do a procedure, to do a task that you are not trained to do so, or you are not allowed to do in your scope of duty, you should refuse. Because if you do it, and definitely something is going to go wrong, you are responsible for it. So that's basically what it is. That will be malpractice because you're practicing something that you don't know, that you don't have certifications, that you don't have training for it. Forget about the training that you have somewhere else in your country if you're not from here, like me. So Forget about that, because when you come to this country, or even though if you are from this country, you have to be certified, licensed to practice whatever task you are doing. And if that task is not within your scope of duty, then you're not supposed to be doing it. Because if you do it, something goes wrong, because usually it's going to go wrong because you're not trained to do so. It is malpractice. Now, negligence, on the other hand, you were trained to do that. You have a license, you have a certificate to do the job. It's just that you just disregard it. You just didn't care. And things are not going to go right because you just did something because you just want to do it, but you weren't paying attention. And the patient ends up being injured. Both cases, malpractice and negligence, the patient is going to be injured. That is the problem. Because if the patient didn't get injured or didn't suffer any consequences of your wrongdoing, then there is no malpractice, no negligence. It has to be consequences of your wrongdoing in order for us to call it malpractice. The patient is not going to sue you because you are doing well, because everything that you did and you are giving the patient works for the patient. Patient is going to be happy. Who's not going to be happy? But if you do something wrong, first they're going to figure it out if it was negligence or if it was a malpractice. So the questions that you're going to get in your exam are about negligence. So they're going to give you a question that reads more likely like this. Okay, so you're working in any medical setting, right? So you're the medical assistant and you do a procedure that you weren't trained to do. What is called? You're gonna look for negligence. Look for negligence. You didn't do what you were supposed to do. You were trained to do something, but you didn't do it. So that's called negligence. So usually malpractice, they don't ask about this. They ask about negligence because usually it's within our scope of duty that we don't do the things. You're supposed to do this, but you don't do it. You were trained to do that. You did it wrong. So the patient suffers the consequences of your wrongdoing. So that's basically what it is. So usually in the court of law, they're going to put a medical professional and the medical that is being sued. A medical professional who is a witness, and it's called an expert witness. What is called an expert? Because he knows about what is it that the doctor is being sued for. So they're going to ask the doctor, who is the witness. They're going to ask you, okay, so in this situation of the patient, the situation that the patient is suing for, what would you have done in that situation? Then that doctor is going to say, okay, if I were in that situation, I could have done this. And they start saying what they would have done for the patient. And whatever the doctor, the witness says, doesn't match what the other doctor did, you're in trouble now. Because every single doctor in his or her profession should do exactly the same in the same circumstances. Let me give you a clear example. Let's say that I'm a general doctor, a family practice doctor. If I'm a family practice doctor and I'm being sued for malpractice, then guess what? They're going to put as an expert witness a family practice doctor. They're not going to bring someone else. Has to be in the same field. If you as a medical assistant are sued for negligence, who they're going to bring as an expert witness? A medical assistant. If a nurse is sued, who is the expert witness? Another nurse. Why? Because you have to put me, the defendant, who is the person who's been accused, in the same category, in the same place, in the same profession. What is a doctor knows about medical assistant? What is a nurse knows about medical assistant? Nothing, has nothing to do. So if I'm interviewing a female about pregnancy, who am I going to call? Another woman. What is the male going to know about pregnancy? Nothing. So it would make no sense. So that is negligence. You do something wrong. Wrong means that the patient suffers the result of your wrongdoing. So it's going to suffer some consequences. It's going to be injured or it's going to die. Worst case scenario. So that's negligence. It's unintentional. It was not on purpose. It's not that you don't want to do all the steps of the surgical procedure or the collection of the blood or something else that you have to do, or the diagnosis for the doctors. It's not that you didn't want to get to the diagnosis that you need. No, you skipped some steps. You didn't do exactly what you were supposed to do. Oh, no, I'm going to use a shortcut. This is taking too long. Oh, this patient probably is not serious enough. Probably this patient is not sick enough. Oh, I'm not going to do much. I'm just going to order this, or I'm just going to give these pills. And it turns out that the patient became worse. Now then I'm going to investigate. And here you go. You didn't do what you're supposed to do. So let's say that a patient comes in complaining about cough. Oh, I'm coughing. And then the medical doctor just say, that's the flu. And tell you, okay, so you just have the flu, okay, Mr. and Mrs. Smith? You're going to go home. You're going to be drinking lots of fluids, getting a lot of rest. If you have pain or headache or fever, just take Tylenol. Oh, you can buy over the counter. You don't need a prescription for that. The patient goes home and it turns out that the patient didn't have just the flu. How do you know you have the flu? Just because you have the cough? Remember, COVID has the cough. Tuberculosis has the cough. Asthma has the cough. COPD has the cough. Bronchitis has the cough. So wait a minute. The patient end up with a serious condition and end up in the emergency. And they're going to tell them, hey, what is it? Why didn't you come before? Now you are very serious. You're sick very... say, no, I went to my doctor. Oh, yeah, that's it. That's how we start the whole issue. Everything is going to go back to your doctor. Remember, the doctor who's taking care of you is the first target when something goes wrong to the patient. Regardless, they're going to be investigated. They're going to go back to that doctor and see what the doctor has done. So they're going to ask for the medical record number, for the medical records, for the files. And they start investigating all these to see what was wrong, where, what day, during which visit or procedure the negligence occurred. So that's basically what it is. So again, not that simple. So that is negligence. Remember, it is wrongdoing. Later on, we're going to see that wrongdoing in law and ethics in law means a tort. So we're going to go there. So that's basically what it is. If you don't find negligence as something that you're doing wrong, then malpractice should be there. But most of the cases, it's negligence. So pay attention to anything that you're doing that the patient was injured after you did something that was not appropriate, what is called negligence. Negligence. Any questions about negligence or malpractice? Here it is. The tort of negligence. So this word is very important, tort. So what is exactly tort? Go back here. Wrongdoing. A tort is a wrongdoing. Something that you did wrong, but most of the time is unintentionally. See, unintentional. When you work in the medical field, everything is unintentional. You do not kill the patient on purpose. It's just that you neglect to follow your scope of duty. You didn't do the right thing. Something went wrong because you didn't apply your training. You just took it for granted. You assume that the patient doesn't have anything serious. And you just do something to, get off from the patient. And later on, the patient is going to be very sick. They're going to sue you for this. So that is tort. Tort is wrongdoing. So there are three types of torts or negligence, because tort, negligence, wrongdoing. So either or, you can use it as a wrongdoing. But in the court of law, we call it the law. So it's not, oh, I'm suing you for the tort. We don't say that. I'm suing you for negligence, malpractice. Tort is the reason that the negligence was committed, was the act or not doing, not performing your job. So there are three things that can happen with negligence. Negligence. So the first one is just the regular negligence. We discussed about that. So we're going to start with the minor one. Minor in the case that it's not that the patient was not injured. No, it was injured and the patient probably died. But here you are legally entitled to do what you did. It's just that you didn't do it the way it was supposed to. You knew how to do it, but you didn't do it right. So that's basically what it is. So it's called nonfeasance. Nonfeasance. Failure to perform a necessary action. We go back to the patient who came with a cough. The doctor assumed, oh, he just have the flu. She just have the flu. I'm just going to give some cough medication, some pills for the pain, and I'm going to ask them to have some rest, to go home and drink lots of water. Well, it's a failure to perform necessary action because what the doctor should have done is to do all the physical pertaining to that cough. Okay, Mr. Miss Smith, for how long you be coughing? Oh, it's like for the past 2 days. How's the cough? Dry? Productive? Oh, what do you mean dry or productive? Do you have any flame coming out? Oh, yes, I saw some flame. What color is it? That is so important. It was kind of greenish. Oh, wait a minute. Right there is telling me you have a bacterial infection. And now, oh, it was like yellowish, like brownish, less clear. Well, now you have a viral infection. So I'm trying to figure it out now else. Do you have any fever? Do you check the temperature for that fever? Do you know how high your temperature was? It was continuous your temperature for how long it stays? So this is how we are going to know whether you did what you were supposed to do. Then, okay, anybody in the house has the cough? Have you been outside of the country? So we have to rule out different conditions. It might be tuberculosis. It might be malaria. It might be so many things that make you cough. Just cough by itself is a very general symptom. You can cough for almost anything. It can be serious, might not, but you take it as it's not serious when actually was serious because you didn't do all the steps to find out whether this was something serious or not. So this is called non-feasance. You are licensed, you are certified to do these procedures, but you didn't do every step that you're supposed to do to figure it out what was going on with the patient. End results, patient injured. Patient end up in emergency, now have a surgical procedure, probably patient dies, big problem. See, non-feasance. Now let's move to misfeasance. Think about mix. It's a combination or non and something else. Now, improperly otherwise proper or lawful act. What is all that? Well, now you are doing something that you were not supposed to do. But guess what? You do have a license. You do have a certificate to do something within your profession, but you went beyond that. See, the other one was failure to do what you trained to do so. That's non-feasance. So you kind of protected more than the next one. So this is not that it's not serious, but let's say this is number one. This is number two. So those goes on a scale from mild to worse. So misfeasance, you do have certificates, you do have a license, but you did something that you were not trained to do. Let's go back to the doctor. Let's put it this way, I'm just gonna make it up. Let's say that I'm a family practice. Patient comes with a tumor and I do surgical procedure to remove the tumor. Oh, wait a minute. The patient then dies or something happens to the patient. So this is wrongdoing. This is inappropriate because as a family practice, I'm not supposed to be removing tumors. That is a medical specialist. That is a surgical oncologist. So what are you doing a job from somebody else? And look at the results. Now the patient probably has more issues, serious issues. So remember, one, you failed to do what you were supposed to do, non-feasance. The other one, you did something that it was not within your scope of duty. You weren't trained to do so. So that's called misfeasance. You have a license, but not a license to do that. Let's say you're a medical assistant and the doctor or the nurse or you decide to give an injection to the person. When you give an injection, the patient has an allergic reaction to the medication. That is misfeasance. Why? Because you are giving injections, medication, you are administering medication when you're not supposed to do that. Yes, you're a medical assistant, but you're not supposed to do that. That is not within your scope of duty. So you will be accused of misfeasance. Think about this. That's what I've been telling you all the time. Don't do anything that is not within your scope of duty. That doesn't say, hey, medical assistant, this is what you can do. Doctor, this is what you can do. People have the misconception that because you're a doctor, you're supposed to know everything and do everything. No. That's what we have specialties. That's what we have, different specialties. We have a cardiologist, we have a GYN, we have an obstetrician, we have a gastroenterologist, rheumatologist, endocrinologist, oncologist, because each one of them is going to specialize in certain areas, certain conditions, not that you're going to be, we are going to be seeing all these people. And when we encounter a patient, me, let's say that I'm a general medical doctor or a family practice, let's say that I have all these people from all the ages, no problem. So I encounter a patient who's a female, is pregnant. Oh yeah, come to my office, I'm gonna be following your pregnancy. Wrong, that is not my specialty. I'm gonna refer you to a specialist. That's what you're gonna do, an obstetrician. A patient comes to me and say, oh, well, I found out that it has problems with their heart. Yeah, I'm going to do the preliminary of evaluations. Oh no, this patient has problems with the heart, cardiologist. Oh, this patient has problems with the stomach, gastroenterologist. Oh, this patient has a lot of problems with the nervous system, neurologist. Oh, this patient is going a little crazy. Oh no, psychiatrist. I'm not gonna get involved on that because I'm not a psychiatrist, I'm not a cardiologist, I'm a general doctor. So that's basically what it is. The same goes for the medical assistants. The same goes for the nurses. You gotta do what you were trained to do. And remember, according to the American Medical Assistants Association, you can do certain things, right? But when you start working in your place, you're gonna abide what this medical doctor asks you to do. If they tell you, okay, I know medical assistants usually do this task, but I don't want you to do it here, you're gonna do just that. Why? Because that's the person who's paying you. That's the person who hires you. This is the person that you have to listen to. Now, it's not that it's going to be malpractice. You're not going to be accused for that or misfeasance or anything like that. No, it's just that your doctor don't want you to do this particular task in his or her office. That's it. So that's what you have to follow. Now let's move to the worst one, malfeasance. Remember, the word mal means bad, really bad. What happened in this situation? This person is performing a task, a job that he or she was not trained to do, but furthermore, this person does not have license or certificate to do that. So the whole thing is illegal, unlawful. See, think about this. Non-feasance, misfeasance, they are lawful. You have a license, you have a certificate. But in the first one, non-feasance, you just didn't do the job that you were trained to do. Misfeasance, you went and did something that you weren't trained to do, even though if you have a license, but you weren't trained on that. Malfeasance, you don't have a license, and on top of that, you performing a procedure. You weren't trained, you don't have a license, so the whole thing is wrong. This happens a lot, and this happens with medical foreigners, medical doctors. So they come here, oh, I'm a doctor in my country, so here, well, I have to kind of go back again, the school. Oh no, but I'm gonna open my own office and I'm gonna start seeing people from my country. And if something goes wrong, here you are not licensed, Mr. or Mrs. If you're not licensed in this country, your license from your country means nothing. Or you are a nurse and you're doing procedures on your own. As a medical doctor, you don't have a license as a doctor, but you're performing tasks as the doctor, you're going to be in trouble. So those are these type of wrongdoings that are called torts of negligence. Wrongdoings that leads to negligence. That's basically what it is. So non-feasance, misfeasance, malfeasance. So if you are cut off on this malfeasance thing, you are going to be in a really, really bad shape because You're practicing without a license and the patient was injured. So you're going to pay the consequences. There are a lot of doctors, plastic surgeon doctors, that they are not plastic surgeons and they act as plastic surgeons. If they have a license, other license, that is not a plastic surgeon, they're going to be accused of misfeasance. But if they are not neither medical doctor, well, neither a plastic surgeon, well, then you are going to be malfeasance. So these are the major torts. So please try to understand this because these are the questions that you're going to get on your exam. So most of the time, the one that they like to ask, non-feasance, because this is the one that you are part of it. You have a certificate as a medical assistant, but if you do not perform, you do not do the right thing for your patients, then you fail to do what you're supposed to do as a medical assistant. You're going to be accused of non-feasance. So that will be the negligence that you will be accused of. So there are different levels. So that's how they gonna, hit you with during the trial. They have all this information in, they're gonna see where you're standing. Any questions about this type of torts that leads to negligence? Remember, non-feasance is the one that I want you to know because this will be the one that it will come out in your exam, in your national exam. Any questions? Remember, just think about you not doing your job. You're a medical assistant, you're not doing your job, patient got injured. What type of negligence is that? Non-feasance. What type of tort is that? Non-feasance. So that's basically what it is. Moving on. Okay, let's talk about these 4 deeds of negligence. So let me start by saying this. In order for a patient who's called the plaintiff in a court case, remember, the person who sues is called plaintiff. The person who's being sued is called the defendant. Remember, this is how you're going to remember these terms. We're going to see them a little bit further up. Defendant. What is a defendant? The person who is defending themselves against an accusation. So if you accuse me of something, oh, listen, Professor Hoyer, you did not send me the materials for my class. Then you're accusing me of something. So you, the accuser, is called the plaintiff. The person who is being accused is called the defendant. Why? Because you're accusing me of something. I'm going to try to defend myself. Oh, no, wait a minute. Let me check. Let me check your email. Send me your email. I'm going to compare with the emails that I have on file. Oh, by the way, I did send you that. Oh, my bad. You're totally right. I didn't have that. Or I have the wrong email. I'm just giving you an example so you can understand. So you can understand what is the difference between the defendant and the plaintiff. Because they like to ask about these questions. Person who's being sued, how do you call it? Oh, defendant. Because the person who's being sued needs to defend themselves. So, oh, I need to defend. Oh, defendant. Now you know that the other person, there is no way you're going to mix it up. It's going to be the plaintiff. Because if you don't know the difference between them, stick with one. When we have to compare between things, stick with one thing. Learn one thing that you know the other one. So that's how I do it. I remember defendant. Oh, I have to defend myself. So I'm the defendant. So the other one, I'm going to say, oh, that's the plaintiff. I know this is going to go right. But if I try to memorize both of them or learn both of them, probably not going to be in good shape. So you have to try to make your life easier for exams. So whenever you are in a situation that you've been sued for negligence, so there are you got to meet 4 criteria. So these are the 4 criteria that needs to be met if you want to have a case. So let's say that you're suing me for malpractice, but it turns out that I'm not your doctor. You just went to the hospital and you're suing me. You don't have a case. Why? Because I'm your doctor. I'm not your doctor. Why are you suing me? You should be suing the hospital. But when you're going to sue someone, usually you get an attorney. And your attorney has to be someone who is really good, who is keen on these medical malpractices. Let's go back to medical professions. I'm not a surgical doctor. I'm not a psychiatrist. I'm not a pediatrician. I know pediatrician, I can work with that because that's part of what I learned when I was going to medical school. But I cannot get into details with pediatrics patients. So I'm not going to be taking care of pediatric patients because I'm not a pediatrician. I'm not a gastroenterologist, so I'm not getting in cases of that. So the same goes for these these lawyers. You're going to hire someone who specializes in medicine, who specializes in cases fighting for these malpractice cases. Can you imagine getting a family attorney? Oh, that's not going to make any good. So a criminal lawyer, that's not going to do any good. You have to get someone who is on the field, just like medical doctors. You're not going to see you having problems with your heart. You're not going to be seeing the psychiatrist. You're going to see the cardiologist, right? So that's basically what it is. So there are 4 Ds or 4 criteria that you have to meet when you are suing or for you to win the case. Let's put it that way. First, the first criteria, the first D, is called duty. So duty means that I'm your medical doctor. So you're suing me because I'm responsible for your well-being. So I'm your doctor, and if something you think that I did wrong, you're gonna sue me. If I'm not your doctor, you cannot sue me. Oh, somebody else saw you in my office and you're gonna sue me. No, you have to sue the doctor that is taking care of you because this is the one that made the malpractice or they make the mistakes, so to speak. So duty first with that doctor has to be your doctor. If I'm not your doctor, you cannot sue me. If this is not a hospital where the doctor works, that you have the so-called negligence or malpractice, you cannot sue my hospital. You cannot sue my medical office. You have to be a patient of this hospital for you suing this practice. Now, you are being seen somewhere else for other things, and then you come and sue me. Oh, wait a minute. I wasn't seeing you for that. I refer you to this medical doctor, or you refer yourself to this doctor. They were working with you. Yes, you're my patient too, but you cannot come and sue me for a case that I was not involved, for a treatment, for a procedure that I didn't do, that I didn't perform. So this clear? That's the duty. Duty is that you and I, patient medical relationship, patient-doctor relationship. We established that relationship already. So I'm responsible for you. And if something happens during my watch, so then now I'm responsible for you. But if I'm not, you cannot sue me. So that's the first one. Usually This one, 96% of the time is met because you're not going to be suing someone else who's not your doctor. That's kind of, ridiculous. Second D. So there are four. D for dereliction. Now I failed to do something for you. So I'm your doctor, but I felt I neglect to do what I was trained to do. So that is nonfeasance right there. So during dereliction now, you're my patient. I failed to do something that I was supposed to do as that particular medical doctor. Neglect of duty, nonfeasance. So I didn't do what I was supposed to do. Therefore, you're suing me. Number 3, direct cause. So this means that the reason I'm your doctor, I failed to do something that I was supposed to do because that was trained to do. I didn't do it right. So because of that, you now are suffering. Now you are injured. It was because of my wrongdoing that you are the way that you are right now with your health. So that's direct cause. So it was my fault. I was supposed to be taking care of you. I didn't do the right thing. Now you're going to pay the consequences. Now you are going to take it against me. So that's basically what it is. Last but not least, damages. Due to the wrongdoing, the direct cause, because it was because of you, now I have injuries, damage. See, damage caused by the defendant, because in this case, let's say that I'm the defendant, I'm being accused, and you are the accusers, the plaintiff. So in order for you to sue my office or sue me, you have to meet all these criteria. Remember, if I'm not your doctor, you cannot sue me. Then your attorney will say, no, we're gonna sue the hospital, the medical office, because all these doctors works there. So whoever took care of you, it doesn't matter, we're gonna sue the office, because what we need is money. And we're gonna fix the problem because they cause you a problem. So that's basically what it is. Now, if one of these D's is not present during the investigation for the case to be brought in front of the jury, then there is no case. The attorney is going to say, okay, something sounds fishy. We don't have a case. There is no case. What are they going to go there to fight for? Because it's not what the attorney says. This is the attorney representing the plaintiff, but my attorney representing my clinic, me, is going to know the same things, probably more. This is defending the medical providers. So you have to meet the 4 Ds. So be careful in your exam. They're going to ask you about these Ds. So which of the following is one of the 4 deeds of negligence? And they're going to give you one. Most of the time, they like to use 2 of these. So think about duty and direct cause. That can change. So keep in mind duty, dereliction, direct cause. And damage, because one leads to the next. So you need to know this because They keep on changing all these answers all the time. At least you know whenever you have a question about the 4 deeds of negligence, you know what to do. You know that we cover this. You know that you're gonna have an idea. So that's basically what it is. So remember, if one of these deeds is not part of whatever happens to you, the case is gonna be dismissed. Withdraw. There is no case. You have to have the 4D in order for you to have a case. Any questions about the 4 deeds of negligence? Okay. Okay, so this is also part of the proofs for the negligence. So this is a Latin word for the thing speaks for itself. It's called res ipsa loquitur. This is a Latin word. Well, you have to know this. This is a question for exam. Remember, I'm going to tell you in advance most of the things that you are going to encounter in your exam, because they like to ask this, because this is very important. So they're going to ask you, okay, this Latin word res ipsa loquitur stands for what? Then the things speak for itself. But it's not that simple, because they're going to give you a case. So I'm going to tell you what the thing speaks for itself means actually. Let's say that a medical doctor did a procedure, right? And during the procedure, we have all these instruments, all these supplies, and whatever comes in for the procedure needs to leave the operating room. So if I have 2 scissors, scalpel, well, so many things, sponges, forceps, whatever instruments that are using over there, if I brought like 10 instruments, how many do I have to have at the end of the surgical procedure? 10. If I have 20 sponges to wipe off the blood from the surgical procedure, how many do I have to count at the end of the procedure? 20. So when you're going to start the surgical procedure, we count how many instruments, how many pieces of supply, whatever we use, we have to count all of them. I brought 10 of these, 20 of these, 5 of this. When finished, before we close the patient up, put stitches, whatever the case may be, we're going to count the things, because it happened many times that a piece of equipment or supply has been left inside the body of the person. The person is going to get sicker because you cannot have foreign body inside. So then you're going to get sick. So later on, the patient is going to get sick and, oh, I'm feeling so bad. I have a pain here. And, oh, that's your surgical procedure. You're going to feel like that for quite some time. So keep on, following up with your doctor, blah, blah, blah. The patient develops an infection, fever, end up in the emergency. They do an x-ray, sonograms, CAT scan, MRI, whatever the case may be. Boom. They find out that you left pair of scissors inside, and a scalpel inside, a forceps inside, and a spongy inside. That is what it's called the thing speaks for itself. How can you deny that a pair of scissors were found inside your body? There is no way. It's there. We found it. It is in an x-ray, in a CAT scan. It is in a sonogram. We have proofs. So when the medical provider leaves something inside the patient, that is called malpractice. That is negligence. That is a tort. That's a wrongdoing. They didn't do it on purpose. I'm not leaving this pair of scissors or this scalpel or these forceps or these sponges or whatever other things in there, I didn't leave them on purpose. That's what is called unintentional. But you were careless because you were supposed to count every single thing that we bring in is supposed to go out. So that's the case that they're going to give you. They're going to tell you, okay, so what term you're going to use? So what is the answer? What is the correct answer for patient went to the medical office and they left something inside? So they're going to tell you that they found something inside the patient. So that's called res ipsa loquitur. And if you don't find that, you have to look for the things speaks for itself, because that's basically what it is. We found it right there. I don't need any other proofs. Things speak for itself. I'm seeing the piece of equipment inside. I personally went through that. A patient came off to the emergency, and well, to make the story short, because it was a long story, because the patient's been there several times in the emergency with abdominal pain. But they disregarded. They said, oh, well, this is about the surgical procedure. You are healing the healing process, but it's been 3 years. It's been 4 years now. Well, I got the patient. And when the patient told me that was having a, abdominal pain, I asked all the pertaining questions. And one of the questions that I asked, because you always have to ask, is like, have you have a surgical procedure in the past? So it says, yeah, I have a surgical procedure and I have it here in this hospital like 4 or 5 years ago. So I said, okay, what type of surgical procedure was that? And they said that was an open surgical procedure. They removed the appendix, blah, blah, blah. So I said, okay, so 5 years, that's too long, should have healed by now. An appendicitis is not a big issue. That's a very simple procedure. Wait a minute. I send the patient for x-rays. Guess what? They found a pair of scissors in there. I'm telling you, not lying. The x-ray technician called me immediately as soon as did the x-rays to the patient, and says, oh, check your system. Here you're gonna find the results of the x-ray the abdominal x-ray that you sent. When I look at it, you see the pair of scissors right there laughing at you. That is called the thing speaks for itself. I was new there, so I called senior doctors, the director, and I explained them what's happened, because, the patient was seen there. I'm not going to tell the patient, by no means, remember, this is not our job. I just want to make sure that whenever you see something, generally it says, you are in the train station, you are in the train, said if you see something, say something, right? In this case, you're not going to say anything. You're not going to tell the patient, wow, they left a pair of scissors inside you. You should sue this hospital. You should sue your doctor. Those are not the right things to do, because you're a professional. We don't do anything else. Whatever they do it on their own. Is that understood? We don't do that. We don't talk bad about the people that works with us. What if that was you, the one that did it? They want to do it. They're going to go ahead and do it, but I'm not going to put any words in their, in their brains, in their mouths. I don't know what happened to the patient after that. The patient was, I sent the patient to surgical department, the surgical doctor is going to remove that and is going to follow with them. I don't know anything else about that case, but it happens, and it happens more often than you think. So that's why these questions are asked. Even though if you're a medical assistant, you're not leaving anything because you're not doing a surgical procedure, but you need to know these kind of things, because sometimes you might be assisting the doctor for nothing surgically procedure, but minor procedure, who knows? But these questions actually comes in exams. So res ipsa loquitur, the thing speaks for itself, means that it is so obvious that you saw something is there, There's no way that someone is going to say, no, I don't think that scissors were there. You put it in there. You cannot accuse the patient that put the scissors inside. No, I didn't surgical procedure. So, see, this problem should have been solved a long time ago because this patient was coming to the office, to the emergency all the time. They didn't run that. And guess what? Well, it wasn't, my issue, but that's how it is. So that's what it means. The thing speaks for itself. Any questions about it? Remember, I'm giving you kind of a little scenarios so you can remember these things, because otherwise, if you just start reading right there, you're not gonna get it easily. Damages. Remember, the damage is the injury the patient suffers due to the negligence, due to the malpractice, due to the tort, the wrongdoing. That's basically what it is. I'm mentioning all these terms because whichever you encounter there, you're gonna relate it to it because it means the same. So compensatory damages. As the word implies, compensatory, we gotta compensate the patient. For what? For all the time involved in going to the doctor, to the attorneys, going to court, and all the stuff. Even though if you don't win the case, you're gonna get compensated for all the time that you're gonna spend trying to sue the doctor if there was a case. You're gonna get paid for it. So there are compensatory damages for the damages that I caused to you. I remove the wrong organ. That is the damage that I caused to you. I perforated an organ during my surgical procedure that I was not supposed to be involved in the surgical procedure. Now I'm causing you damage inside. I didn't do what I was supposed to do. I left something inside that caused you an infection, a problem, not healing properly. Compensatory damages. You did something, you damaged my car, you pay for the damage. That's it. You fix my car. But there are punitive damages. Now, every time that there is a case, this is kind of place, both of these type of damages are included in the award that you're going to receive. The money that you're going to receive if you win the case. You're going to get compensatory damages, punitive damages, psychological damages, emotional damages, so many damages. But the punitive damage is to teach the person that committed the damage a lesson. That's basically what it is. So this is to teach the hospital, hey, next time, I'm going to sue you for this because next time you're not going to make the same mistake. That's basically what it's telling you. So you're paying me for the damage that you caused me physically, emotionally, but then you're going to have another money that you're going to pay me because I'm going to punish you for what you have done. Because usually these medical doctors, they don't go to jail. You're not going to send the hospital to jail, are you? So usually it's monetary compensations, what we pay for the patient, for the plaintiff. So that's basically what it is. Oh, you try to get away with the case, delaying the case, making false statements, bringing, funny witnesses, blah, blah, blah. Well, you know what, clown, you're going to pay for that. So that's basically what punitive damages are all about. Remember, compensatory, are you compensated for the damage, for the actual damage that you caused to me? Remember, compensatory damages, You damage my car, you crash my car, the mechanical doctor is, oh, mechanical doctor. The mechanic is gonna say, oh, wow, this car is gonna cost you this much. Oh, you gotta fix it then. And you gotta pay for it. But then, because you were driving carelessly, you're gonna have more money that you have to pay me. So you pay for my car, but you're gonna pay for these too. So you next time you learn how to drive. That's kind of the way that, I'm giving you kind of simple example. Any questions about damages? This will not be on your exam. They're not going to ask you about, okay, how is the patient is going to be compensated if he wins the case? No. But you know that there are different monetary awards that the patient is going to receive, whether it's just for the damage itself and to punish you as a medical professional for being a bad professional, or the hospital for having someone who is not a good professional. Just put it that way, simple words. Any questions about damages? Moving on, fraud. Pay attention to fraud because fraud is a very, very common question in exams. So what are the key to know that this is fraud? Very simple. So here is the definition. Fraud, the deliberate or intentional act of deceiving someone for personal or financial gain. Now think about this. Fraud means that you did something knowingly, intentionally, to deceive someone. So you're doing something on purpose. That is fraud, with the intention to gain something personal or monetary or financial. So that's basically what it is. It's very, very common in every single industry. Anything. You name it. Fraud is everywhere. So one of the most common types of fraud in the medical is billing for services that were not provided. Think about this. Here, billing for services that were not provided. You're gonna say, oh no, how can a medical doctor, file a claim to the insurance company for services not provided? Yes, it happens, and it happens all the time. How so, professor? Because the doctor is not that didn't do the procedure at all, but is misrepresenting that procedure with something that's going to pay them more. Let me give you an example. Very simple. You go to the medical doctor and you have a follow-up. You make an appointment, you have a follow-up visit. Then usually you don't have anything serious this time. You're just gonna go there for blood results, from X-ray results, or any imaging reports result. The doctor didn't spend 10 minutes with you, but the doctor billed you for 45 minutes, for 30 minutes. That is fraud. You're billing me per procedure, you didn't do it, because what is it that spends 30, 45 minutes? It was a follow-up. It was a 10, 15 minutes most. Now you're billing for 30 minutes, 45 minutes. But you don't know that because we use codes. And each code represents the visit type. And each visit type with that code tells me it was a 15 visit code. It was a 30 minutes visit code. It was a 45 minutes code. It was 1 hour. Each of these codes represents time and the type of procedure that you did during that time. And who is going over all these all the time? Well, many things just goes unnoticed. But eventually, these medical doctors are gonna, are gonna be caught. Medical doctors write down that you have an X-ray when you actually didn't have it, an MRI when you actually didn't get one, a sonogram, an EKG, blood work that you didn't get. So who's gonna tell the insurance company that you didn't get that? How do you know what the doctor is billing for? What the doctor is trying to get reimbursement for? So again, this is fraud. Remember, how are you gonna know that it's fraud? Because it says intentional act, deceiving. Just the fact that you are deceiving the system, deceiving your patients, deceiving the insurance, for what? Personal or financial gain. Let me give you another example. Let's say that this person is not a medical doctor, but he came out with a license as a medical doctor, a license as a nurse, but he or she is not a nurse, but he has a license as a nurse. Well, they got it, they bought it, something happened, that's fraud. Personal gain. They want to have a license to say, hey, I'm a doctor, I'm a nurse, give me this job so I can make that money, but it's a fraud. So again, a lot of things happens. So be careful with this. This question comes on your exam 100%. And remember, the way that you're gonna recall this fraud is an intentional act of deception, deceiving someone. And it's intentional. You do it with a purpose. This is not unintentional like negligence. This is intentional. You do it on purpose. I'm gonna charge more to this patient because I want more money being reimbursed. So that's basically what it is. That's fraud. Any questions about fraud? They can give you an example, and I give it to you. Billing for services not provided is considered what? Fraud. This is not negligence. This is not malpractice. No, it is fraud. So think about it. Another one that uses a lot in medicine. Well, I already mentioned it, upcoding. See, billing and coding teaches all these. What is upcoding? See, coding is translating the medical diagnosis into letters and numbers, because we don't bill the insurance saying, oh, I'm billing this patient because I examined this patient with diabetes, because I examined this patient with arthritis, because I examined this patient that has colon cancer. No, that's not how we do. We send a code that represents diabetes, type 1, type 2, gestational diabetes, hypertension, essential, and primary hypertension. We bill for all those things, and we have to be very, very precise with the codes. So here is when we gonna up code. What is up code? Using a different code that pays more for those services, for that procedure, for that time that I already spent with my patient. That is basically what it is, because I want more money. That's upcoding. Now, upcoding, they're gonna ask you, what is upcoding? Oh, this is getting or submitting a higher diagnosis code or service to get paid more. That's basically what it is. So that's upcoding. I know there is more things, but these are the most common that you might be seeing on your exam. So please be on the lookout every single time that you check this question. Remember, fraud, 100%. There is no question you're not going to have fraud on your exam. So, see, this is in your profession. Medical assistants have been involved in several fraud cases in the medical office. You can do it. You can charge the patient more for a service that it was less, and you keep the rest. Remember that when we were talking about medical office procedures, patient comes for the first time and they're gonna do this procedure, but they don't have health insurance, so they're gonna pay cash. So you know that the doctor usually for the visit charges 100, 150, 200, depends on location, depends on specialty. I'm just giving you roughly some numbers, but let's say they charge 150. You tell the patient, oh, well, it is 100, it is 200, it is 180. And you think that nobody's gonna know. That is fraud. Knowingly, remember, you know what's going on. You help the medical doctor to change the codes. So you change the code so the doctor get paid more. Whether the doctor told you, whether you did it by yourself, whatever it is, you did it intentionally. And then the doctor is gonna say, hey, if we get this much from these patients, then you're gonna receive this extra. Because remember, you're gonna be receiving some benefits. Or they're gonna say, hey, you wanna be the office manager? You're gonna stay there and get a raise? Well, then you do as I told. So be careful. Not that this is gonna happen, but there are things going on with this kind of behavior with fraud issues. So be careful. When we find a case of fraud, where do we inform this? Do we call 911? No, that's not the agency that we call. We call the Office of the Inspector General. This is a federal case. And this is, they have a hotline for this. If you know that a doctor is doing something like this and you want to turn them in, it is up to you. It's anonymous. Nobody's going to know who did it. And basically, just for you to understand where to report fraud. That's basically what it is. The Office of the Inspector General. So that's basically what it is. Okay. So let's continue. Defense to malpractice suit. So how are you going to defend yourself? So what's the first thing that you do when somebody accuses you of something? Think about it. If I accuse you of something, what is the first thing that you're going to say? No, I didn't do it. It wasn't me. Denial. So the first thing that you're going to do, this is an affirmative defense. No, I didn't do it. I have no idea what this patient is talking about. So that is one of the most common defense mechanisms. And it applies for everything. At home. See, I have 3 sisters. So we like different things, right? Different fruits, different stuff. So I like yellow. My sisters don't like much, but they prepared it for all of us. I was going to the kitchen and take all the yellow, take it to my room, and I eat it. Ice cream. I love ice cream. So they have ice cream for all of us. I usually ate it all. But when my sisters accused me of stealing their ice cream or the yellow, what I did, I said, oh, I didn't do it. Me? I could never do anything like that to my sister. I ate it all. Again, this is how we act. You break something, you spill something, you make a mess at home, and they ask you, hey, Alberto, did you do this? No, I didn't do it. Who's going to say yes? So this is the way that everybody by nature defend themselves. It's saying, I didn't do it. There is another way to defend yourself in a positive way. This is how, well, if I said I didn't do it, well, then they have to bring proofs, right? I'm not going to say, yeah, I did it. I'm sorry. I wouldn't do it again. Yeah, the patient lost her leg or her kidney. Oh, I removed the wrong organ. I'm sorry. I promise not doing it again. That's not how it works. So the first thing that we do is we deny it. It didn't happen. It wasn't me. It wasn't my clinic. It wasn't my doctor. It didn't happen. The next one is going to be assumption of risks. We're going to discuss that ahead. Statute of limitation. Gonna talk about that, how a medical doctor uses these particular defenses just to make sure, that they get away. No, I didn't do it. Assumption of risk. We're gonna read what happened because this happens during the consent, the informed consent. When we inform the patient about all the risks and benefits during this procedure and what the options are, and if you agree with this, you sign right there. So I'm gonna tell you, you knew that there were some risks right there. So hey, you knew that this could happen, this might happen, and eventually happen. So I'm not responsible. See? That's how it works. Statute of limitation. Well, we're gonna discuss this in a little more details. No worries. I'm just giving you a little taste. Statute of limitation. Everything has statute of limitation. Let's say everything has an expiration date. That's what statute of limitation means. We have an expiration date for everything. So statute of limitation is about 2 to 3 years. Wait a minute, because there are more. It's not that simple. So once again, this is something that the defendant, remember the patient, the person who's been accused, that is going to use as evidence to be clear, to the case to be dismissed. So that's basically how it works. And the other one is contributory negligence. Think about all this. It sounds like, oh, wow, this is a lot of terms, right? Denial, assumption of risk, statute of limitation, and now the contributory negligence. It wasn't my fault. It was the fault of the patient because the patient did not follow my instructions. And this can happen. See, this can be real. That's what it says, affirmative. That might be true. You accusing me, but I wasn't your doctor. So I'm going to deny that I did that. Well, you're going to do it anyways, but it can be real. Assumption of risk. You signed this paper, and I told you that one of the risks, one of the consequences of doing this surgical procedure was this, and it actually happens. So why are you suing me now? You knew already. You were aware of this before the procedure. You have the option of saying no, to refuse the treatment, but you went through it. But it's because I trust the doctors. I told you were. No, I told you what the risks were. And here it is, actually happens. You cannot sue me. And there's no case. For the statute of limitation, it's the patient doesn't know anything about this. Assumption of risk and contributory negligence has to do with the patient. So let's talk a little bit more how that works. Denial defense. See, why is we are using this defense mechanism of denial. See, plaintiff, who is the plaintiff? The person who's suing. Must prove defendant, who is the defendant? The person being sued. Did the wrongful or negligent act. So you are the one who has to prove. It's the plaintiff. It's not the defendant. Well, who sued me? If you sued me, you have to have all the proofs that shows that I committed this malpractice or negligent act or just the wrongdoing. It's not the defendant. The defendant is not suing themselves and I have to prove myself that I didn't do it. No, that's not how it works. You sued me, now you have to prove that you have enough evidence to win your case. That's basically what it is. So that's a real, very hard issue to do. Because if you don't have enough proofs, you don't meet the force deeds, this is it. Case is withdrawn, is dismissed. Is the most common defense. I already told you, the first thing that we do when somebody accuses us of something is you deny it. You say, no, I didn't do it. It wasn't me. And we use this all the time. It's so common that we use it all the time. Probably we did it today. We just told someone, no, I didn't do it. Oh, it wasn't me. So in the court of law, when all these cases brought to in front of the jury, they must determine if the defendant caused the injury the plaintiff is claiming about it. And for that reason, you have to prove it. And the court is going to provide an expert witness. Remember, the expert witness is not brought by the plaintiff, neither by the defendant. It's by the jury. It's by the judge who is preceding that case. Can you imagine the plaintiff? I'm bringing my expert witness. Well, it's going to be on the plaintiff's favor, right? And the defendant bringing their own expert witness. Hey, you're going to act on my behalf. That's what you represented me. No, this is someone neutral. It's not from the plaintiff, neither from the defendant. This is someone that the jury, the court brought, and is going to be a mediator, so to speak. So expert witness means someone who knows about the subject matter. Someone is a doctor or a nurse or medical assistant, depends who's being the defendant. Who knows what a medical assistants do, who knows what the nurses do, who knows what the medical doctors do in this particular specialty. We are talking about medical. If it is an attorney who's being sued, who's going to be the expert witness? Another attorney, and in that particular defendant practice specialty. So denial is going to be the first thing. Remember, this is going to be used all the time. We all are going to say, oh no, it didn't happen right here. It's not our fault. Do whatever you want. And then when you have all the proofs, now the plaintiff has to prove it. Assumption of risk. So here are a little more details, but once again, what actually in sum this has to deal with is that when you sign the consent before the surgical procedure, we were very clear about the risks associated with this particular procedure. Mr. and Mrs. Smith, did you sign a informed consent for the procedure? Oh, yes, I did. They have it right there because it's in the medical record. Did the doctor explain it to you that this particular risk and they're going to read it? that you will probably bleed during this procedure, that some of the adjacent organs might be damaged by trying to remove or cut through these particular organs, tissues. Yeah. Did I tell you that this organ in particular is the one who's going to be work on it, operated on it, remove? Yes. Okay, what about probabilities of dying during the procedure? Yeah, but I thought that that was not happening because they said that it was 1 in a million. Well, you are that 1 in a million. Sorry, you lost the case. So that's basically what it is. For that reason, remember, just for the records, you need to understand that this informed consent is very important and it has to be done. Remember, informed consent will be asked on your exam. And what is an informed consent? Remember, inform. You informing me about all the risks, the benefits that I'm going to receive or I will go through during the procedure. If anything of this happens and it's written there, so in the consent needs to say what surgical procedure is it, explain it, or removal of the appendix, or a mesh on the urinary bladder, change or fixing, repairing a valve of the heart, anything has to say there. Who is doing the operation? Who's the medical doctor? Who are the medical assistants? Oh, the assistants doctors, not the medical assistant. Who other doctors are assisting the doctor who's doing the surgical procedure? Who is the instrumentist? Who's going to be the nurse anesthesiologist or who's the anesthesiologist? Everything has to be there. It has to be there also all the information about other options. Remember, the patient needs to know if there are other options besides that particular surgical procedure, because the patient is scared that something might go wrong, because one of the risks is I might die during the procedure. Remember, this consent, informed consent, is voluntarily. It's not obligatory. It's not an obligation. So if you don't want, you can refuse, period. That's it. But you need to understand how it works. So that's basically how this assumption of risk is used in the court of law to defend to the defendant's side, you know. So that's basically how it works. Remember, the patient is going to sign. And if the patient doesn't sign, then we are going to write, the medical doctor is going to write, patient refuse the treatment. And the witness, someone who's there, is going to sign to testify that this patient refused and didn't want to sign. Then we bring a waiver. And that waiver, we're going to read it to the patient. The patient don't want to sign it, no problem. If he sign it, fine. If he doesn't sign it, no problem. Doctor sign. It says patient refused to sign the waiver. Then there is a witness there, and that is it, the doctor signs. And we keep these documents in the patient's medical record. If something happens in the patient sue the doctor because they didn't do the procedure, says, no, I wanted to do it, but you say, no, here is the paper, see? You sign it, or you did refuse to sign, and you have all the rights to refuse, but we have the waiver. I have a witness during that particular evaluation, and you didn't want to, so that's it. So that's assumption of risk. We have proofs that you knew ahead of hand that this particular risk will be present. Regardless if it is 1%, 10%, 50%, it doesn't matter. But if it's written there that one of the risks is this, or this, and it happens to you, you do not have a case. That's assumption of risk. You assume that something like this might happen. You sign it, you were conscious about it, we explain it to you, we ask you questions. Do you need clarification? Do you need any other information? You want to have a second opinion? I don't know. Think about it and let us know if you're going to sign it or not. This is not something that you're going to sign it now, or it's now or never. That doesn't work that way. That is voluntarily, remember. Contributory negligence. Now, as I mentioned before, if the plaintiff, the patient, because remember, it's the patient who's suing the medical doctor in the office or the hospital. It's not the other way around. So if the plaintiff was the contributory cause of the injuries because the patient or the plaintiff failed to comply with the preparations, post-operative, post-op procedures. Patient after the surgical procedure was supposed to follow up with the doctor, take medications to prevent infections. They give you all the medications and told you what to do, not do this type of exercise. You should not go work, don't do this, don't take this, blah, blah, blah. But the patient didn't follow through. The patient did not take the medication, didn't take the antibiotics. The patient developed an infection. The patient ended up in the emergency. Now the patient wants to sue the doctors because they didn't do a good procedure. It's not the procedure. My procedure was good. You didn't follow through. It was you who caused this. You contributed with whatever happens to you, because if you have taken the antibiotics, you have no fever. You have a fever even though if you take the you have an infection, even though if you took the antibiotics. You have a fever, you took the anti-fever medication, so to speak, and then you didn't follow through. You didn't call us. You didn't let us know that you were sick and you stay at home. Well, it is you. It is you. It's your problem. You were supposed to follow up with us because after the surgical procedure, we're going to follow up with you. We're going to be calling you and you tell us, no, everything is going good. Or listen, you have to return to the office 1 week after the procedure, 2 weeks after the procedure. But if something goes wrong, if you feel these symptoms, fever, redness in the area, is oozing, blood is coming out, some liquid, some serum liquid is coming out from the injury. It got swollen, it got red, it got changes color, like purple, like greenish, pus is coming out. You got to come to us immediately or go to the emergency. You didn't do it, so now it's your fault. That is called contributory negligence. You're not going to receive no money. Nothing, because it was your fault. It's not the procedure that I did, it's that you did not follow through the post-operative procedure. It was your fault. See how things works? That's a case where you don't have that's when you don't, that's a situation where you don't have a case. Ignorance of facts and unintentional wrongs. So this is the thing. Sometimes we think, oh, well, I didn't know about it. Oh, because I didn't know about it, well, I did it and something went wrong, of course. But in the medical, in a professional setting, in the court of law, being ignorant, not knowing the things is not a good defense. On the contrary, if you didn't know what you did, anyways, why do you do that if you didn't know how? Oh, I didn't know that if I do this, something is going to happen. Well, you didn't know, right? You know, so that's the reason what happened, because you didn't know. If you are not aware of something, don't do it. So that's basically what it is. Because you, as a medical professional, you, as a human being with all your five senses, a competent adult, know what is right, what is wrong. So you know if something that you do might cause something else. So that's basically what it is. So you cannot come out with this particular defense. Oh, well, I didn't know. Oh, they asked me. Oh, they asked me to do it. Well, I wanted to do them a favor, but I didn't know that this was going to have consequences. And we have gone through that. We just want to be nice. Or you are pretending to be nice in the court of law, because that was not the intention to begin with. So just the fact that you use this term or not knowing something is not going to help you. It's not. On the contrary, it's really going to put you on the hard spot. Arguing that a negligent act is unintentional is not a defense. Oh, by the way, he already had that. I tried to fix it. It didn't come out right the way that I thought, the way that I was planning, but it was bad anyways. Well, that was the reason that you did it. That's the reason that you tried to fix it. It was good. You're not going to fix something that is good. You're going to fix something that is wrong. So you know, so you're in trouble. So in your workplace, never tell your boss, oh, well, I didn't know that. Well, if I knew, I have not done it. Well, what do you do it if you didn't know? That makes no sense, like contradicting yourself. I didn't know, but I did it anyway. You didn't know that was going to come out wrong because you didn't know what you were doing. That's what you're telling me. But you knew as a human being that, this might end up really bad. How I'm going to try to do something that I'm not trying to do? I never done it. Oh, but I'm going to do it. Well, I'm going to do it on something else. In my home, I'm going to try just to, place a screw somewhere in the wall to put a picture frame over there. And I damage the wall. I do some, well, nobody's going to sue me. This is my place. But with another individual, you don't do it. Sometimes it's better to just say no. It's better to say no. I said no, but you have to say it in a professional way. So remember, you as a medical assistant, you are going to be on your foot. You're going to be saying no when you are not trained, when you were not trained to do something they ask you to do it. Because these are the consequences for doing something that you weren't trained to do, or that you don't have a license, you don't have a certificate, it's not part of your scope of duty, you're in trouble. Remember, in the court of law, they're just going to ask you two things. Your name, please. What is your profession? As the profession that you describe, were you supposed to be doing this is part of your scope of duty? No, but there's no buts. But somebody else asked me, the doctor asked me, and I was afraid that I was going to, what are you assuming all those things? You were supposed not to do it to begin with, that's it. But you did it anyway. So don't put yourself in that situation. Believe me, the person that is asking you to do something, they don't care about you. They don't, because if they did, they will not be asking you to do anything like that. So that's basically what it is. I have one of my good friend working as a nurse in a nursing home. A medical doctor was paid to kill a patient, applying a medication. He didn't give the medication, he sent the nurse to give the medication. The medication, the patient didn't check what, the nurse didn't check what medication was, gave it to the patient died a few minutes later. Of course, there was someone in the family who went, I said, oh, wait a minute. Our family member was sick, but he was not sick to die. I just visited her a couple of days ago. Everything was going good. What happened now? Goes to an investigation. They just do an investigation because any patient that dies in a nursing home, it goes to an investigation to see the cause of the death. Well, they found out the medication that killed the patient. Then who was called there? The nurse. And the nurse says, oh yeah, I gave it to the patient, but guess what? The doctor ordered it. Okay, when the doctor, give me the doctor's order. What is the doctor's order? No, they just told me give this medication. Oh, that's how you give medication to your patients? What is the doctor's order? You as a nurse should know better. You never give anything without the doctor's orders. What is the doctor's orders about the medication, the dosage? What is the diagnosis? And what is the route to give the medication? How often the medication was to be given? There is none of that information. We don't have it. So you're guilty. That's it. And do you think that the doctor is going to go there and say, yeah, I asked her to do it for me because I was already paid to do that, to get rid of this patient? You never know what's going on over there. So you got to cover yourself. Because a lot of things going on in your workplace. And they look for the weakest person or the person who does a minor job to put them in a very, very tough situation. So you never know. Just do what you're supposed to do. Have orders all the time, written orders. Well, an EKG is not going to kill anyone. Oh, can you please, medical assistant, can you do an EKG on this patient? What is the patient going to die from? Nothing. Can you draw blood? I need to know what blood is it, to whose patient is going to, what patient is going to be collecting the blood. Which patient I'm going to be collecting the vital signs. If I collect the vital signs from the wrong patient, give it to another one, it might be high. You're going to start giving medication to someone who doesn't have the high blood pressure or the results of these labs who do not belong to that person. So we have to verify that everything is done correctly. Statute of limitation. This is another defense that the medical doctors uses. Remember, when I said medical doctors includes hospitals, clinics, or just the individual. So these cases, in order for you to bring a case, to bring a lawsuit, you have to be within a certain period of time. But this is the trick. There is an exception of the rule of discovery. So let's say that you went to the medical doctor, they removed the wrong organ. You know that happens, you can sue immediately. They removed the wrong arm, the wrong leg. So it's so obvious. It was supposed to be the right leg. They cut the left leg. Oh, it's so obvious. Things speaks for itself, right? So you can sue immediately. You just came out from the OR, but the family can sue immediately because we have the evidence right there. But there are some situations that you discover later on in life. It doesn't matter how long it passes. Let's go back to the case that I have of the patient that has the abdominal pain. The patient has come to the place, well, according to the patient, several times with abdominal pain, but they never did an X-ray or sonogram or a MRI, never looked inside the stomach to see what was going on. Instead, he was sent home with some pills, pain medications, and probably antibiotics, anti-inflammatories. Says, "Oh, go home. That's the result of your surgical procedure." Still in the process of healing. Seriously, after 3-4 years, my surgical procedure still healing? Huh. So this is the case. Now this patient found out that has a piece of scissors or pair of scissors inside his abdominal area. This is the time that he discovered the malpractice was done. The negligence occurred. So therefore, this patient can sue now, but it has between 2 to 3 years from now to sue. If he, after discovering that these pair of scissors were found inside his abdominal area, he does not sue, and somebody else says, "Why didn't you sue? You go sue." But it passed 3 years after. Sorry, statute of limitation ran out. So if you discovered that the problem was now, that's the discovery time. But if you discover that later on, now it's a different issue. That is for an adult. Now, the statute of limitation is different for children. So let's say this case. During birth, the child was damaged. They were pulling the child from the shoulders. One of the arms were dislocated or injured or were cut or something else. Or something happened to the child. They didn't deliver the child on time. Now the child has cerebral palsy. He's mentally retarded. So two things are going to happen. The family can sue now on behalf of the child. The family is going to sue because it was the fault, because you left the child too long inside the womb, no oxygen, child developed cerebral palsy, mentally retarded. Okay? So the family is going to sue. But when the child reaches the 18 years of age, the child can sue, or the family can sue again on behalf of the child. Because now it's the child that is suing, not the parents. Because children cannot sue, right? Because they are underage. But the parents can. And when the child reaches their majority age, which is 18, they can sue again. So again, there are a lot of things right here that come to play. So this is just for you to give you a little taste. Because never know, somebody might encounter this situation. So that's basically what it is. So the statute of limitation varies from state to state. Some states says 2 years, some states says from 2 to 3. That's it, from the time of discovery. This rule applies. So that's basically what it is. So you can sue immediately because you know already that something was wrong done to you, but then you can sue after when you discover that something was wrong because they found something else that was the cause of the problem, the injury that you have. Any questions? Professional liability. Civil liability. So in the court of law, well, the law, we have criminal law, civil law. Just put it that way. So the criminal law just punish everyone for any wrongdoing. Well, parking violation, light violation, driving without a license, robbing something, stabbing something, killing someone. That's civil liability. Oh, that's criminal liability, the criminal law. Now, the civil law has to do with medical professionals. So if you encounter a question when they ask you which branches of the law are abide by medical professionals or will punish medical professionals, the civil law or private law, but the civil law is the one. So it says right there, the civil liability cases. Physicians may be sued under a variety of legal theories, meaning whatever, you do, because you are sued in the situation that was unintentional. Remember, most of the situations in the medical field, as a medical professional, you didn't intend to do that. It just happened because you were careless. You were not focusing. You knew how to do it. You just used shortcuts, or you just didn't pay attention. You dismissed it. You disregarded it. You omitted something. You didn't do the whole things as any other medical professional could do it. So that's basically what it is. So that is professional liability, meaning anyone in a professional setting is liable, is responsible for any wrongdoing. That's it. That will be the person. In this case, physicians, nurses, physical therapists, medical assistants, anyone who do something against the well-being of the patient, you're going to be liable under this civil law. This is for civil cases. But also, professional liability can depend on the physical conditions of the premises. What is the premises? It's the place, it's the location, it's the hospital, it's the clinic. I got injured in your clinic. I was walking on the hallway. I tripped over something that was left over there. I didn't see it, but that's not my fault. It shouldn't be there. The wets were the floors were wet, so I slipped. I broke my leg. I broke my back. I broke my head. I don't know, something. My arm. Something happens to me. I was exposed to a chemical over there. So that is physical conditions. There was a fire. They didn't have fire extinguishers. They don't have the signs for me to evacuate. They didn't have an emergency exit. They have only one exit. Everybody tried to follow the same thing. We couldn't get out on time. So any of those are physical conditions. The place, the location, the building, the equipment that you're using, it was malfunctioning. It didn't work. I got trapped inside a MRI machine or a CAT scan. I got burned by this particular procedure that you did. Not because it was because of the machine. The equipment was defectuous, was malfunctioning. So that's basically what physical conditions of the premises are all about. Illegal sale of drugs. Now, remember that I don't like to say drugs because it sounds like illegal drugs. These are medications. What do you mean? What do you mean then they sell medications, illegal sell medications? Well, it comes illegal when you are giving patients medications that are not these controlled substances. So these are level 2 medications that are that the patient becomes very addicted. When we get into pharmacology, we're going to talk about all these 5 levels of the medications. So level 2, particularly, are all those medications that make you, become addicted, like hydrocodone or hydrocodone. All these codeines medications are very highly, very highly addicted. And patients are, just because the patient asked me for it, I'm not supposed to be prescribing these medications to them. So that's like illegally selling drugs or medications to them. You're not supposed to be giving refills for these type of medications. The medical doctor is the only one who prescribes this, and only once. And if you want more medications of this, then we refer you to the pain management doctors. They are the ones who are going to be dealing with you. And they are the ones who, if you need these medications often, they're going to prescribe it, but no refills. Every single time that you need the medication, you run out of the medication, you have to go to these particular doctors. But any regular doctor is not supposed to be prescribing this in a regular basis. It doesn't work that way. So that's illegal sale of medications. Or giving the medications to someone that doesn't need it, but the family member need it. Oh, I don't have insurance, but my family member has insurance. So can you give me this medication, like prescribe it to me, but actually is for my family member or for my friend? This happens all the time. But when the patient gets in trouble or not so-called patient, then they're going to sue. And that's when they're going to find out that they were getting these medications through someone else, but from this particular doctor, they get in trouble. That's what we are talking about here when we said illegal sale of drugs, nothing else. And that's professional liability. And if you are doing some type of other illegal drugs, well, then it's a different issue, because then you're going to lose your license. Your license is going to be revoked. If you're using drugs like morphine, codeine, well, then it's a different issue. Okay. So let's take a break. Let's return at 7:35. And we're going to continue with this chapter. If you have any questions, well, ask me when we come back, okay? Enjoy your break. Remember, 7:35. Okay. See you then.
Got it.
Thank you. Okay. So we are back.
Hey.
Hey.
Okay. So, oh, Jasmine, is it Joseph? No, Joseph is not yet here. Jasmine, are you there?
I'm here, yes.
Oh, hi, Jasmine. I just got your email, so I'm gonna send you the PowerPoint presentations for this course, okay, for this module. I don't know if you receive any materials from the school. Have you?
No. Like
Okay.
if need be, I would go back into because it's recording on my end, so I record everything and then I take notes from there if I need to go back in. So, but no, I
Mm,
haven't received anything.
no. Okay, so I just got the emails from you and from Joseph that join this particular module. So I will be sending you later on the PowerPoint presentations from this lecture, okay?
Okay, thank you.
And from now on, well, you guys are on my end because I didn't have you in my roster. So for that reason, I wasn't able to send you any information, okay?
Okay, I do have a question.
Sure.
I don't remember covering module 1, 2, and 3. When I
No
did
worries. The only module 1, 2, and 3, what do you mean? Oh,
oh, I'm sorry, chapters.
okay. No, it's not
Um,
chapters, it's lesson.
Okay. I don't remember covering them when I came in last week. I think we were on chapter 4.
No, I know, Jasmine. Don't go find the number of the chapter. Go find the number of the lessons, the times that we meet in the class.
Okay.
Yeah. So don't go like in a chronological order, or so to speak. 1, 2, 3, 4, 6. No, it doesn't work that way.
Okay.
Yeah.
I just wanted to clarify.
No problem. That's what I'm gonna send you the chapters, the lectures for the chapters, so you know exactly how to follow. So you're
Okay.
not gonna
All
be
right.
expecting, oh, what is chapter 1, number 2, number 3, what is number 5, what is number 6? No, I just want you to follow the lectures that I send you because it is summarized, okay? Because the course is very short, and I want you to give you the information that you actually need for this course and for the possible question that you're gonna have on your final exam and the national exam, okay?
Okay. Thank you so much.
No problem. Joseph, how you doing? I haven't met you either. You know, I just received your email, so probably you didn't get any materials from me from this module. Have you?
No.
Okay. So that's not a problem, okay? I already got your email from you and Jasmine. You are the two new students for this class that joined this module on ethics. So at the end of this class, I'm gonna be sending you emails with the PowerPoint presentations from this class, okay?
Okay, thank you.
No problem. Any
Thank you,
questions? I'm
Professor.
gonna send you my email right there when you receive my email. So later on, go check your emails that you're gonna receive from my email from the school. It's not the school email, it's my own email. So from then on, any questions that you may have through this program, you just let me know through emails, okay? For both of you. Well, all of you, but you are
I
the
got
new
you.
ones in the class.
Okay.
So
I do have a
welcome, Joseph
question.
and Jasmine.
Professor, I do have a question. As far as you emailing us, you said it's your personal email,
Yeah.
not the school email.
Not the school email. I'm sending you because these are my PowerPoint presentations. Mhm.
Okay. And when we are taking like um the test, will it be through the school email through Outlook?
No, I'm gonna send you through my email because I send you a PDF format,
Okay.
and I'm gonna give you a few days. It's gonna be a take-home test.
Okay.
So you're gonna review it, you're gonna to answer, and then you're gonna send it back through the same email that you receive it from.
Okay, all right, thank you.
Yeah, but once again, when you receive the email, you can ask me questions, that I usually check my emails very frequently, okay?
Okay, thank you so much.
Not a problem, anytime. That goes for everybody else, but the rest of the students, they've been with me for quite some time, so they know all this. But for you guys that are new in this module, if you have any questions, just feel free, ask me during the class or through an email. That's not a problem, okay? All right, so let's continue with this chapter. Let's go to, we continue with liability. Right here, personal liability or professional liability. So medical doctors are liable. Medical professionals are liable when they promise to cure the patient, because that is actually not true. So you cannot tell the patient everything is going to be okay. We're going to fix you up. You're going to come out from this surgical procedure like you never had this problem before. That is not true. No one is going to come out like the way that you were before you got sick. That's impossible. And if something goes wrong, then what is the promise of the cure? What is the promise that everything is going to be okay? So in the medical, we try to avoid these statements. So when your patient comes in for anything, you are the medical assistant. Don't tell the patient, oh, no worries. The doctors here are so good. They're going to take care of all your problems. Listen, you're going to be fixed. Everything is going to be okay. Don't tell your patients any of this. Instead, you can tell your patients, our doctors are very good professionals here. They will do everything in their power to make things better for you. That's a totally different statement. Because if things do not go right, then there is always, the probability that I didn't promise you anything to the extreme. So that's basically what it is. So love of agency. When we talk about love of agency, think about the contract between the patient and the medical professional. So you want to receive my services, so you got to pay me for it. So I'm going to work for you. So there is a legal relationship between the patient and the medical provider. So that's the law of agency. That's when we have a contract with the patient. The moment that I accept your services or you as a patient, I'm taking responsibility. It's my duty. Remember the first thing, all the 4 Ds. My duty to take care of your medical problems. That is basically what it is. So that's the law of agency. Who's liable? Anyone who works in the medical is liable. Anyone. Why? Because we represent that medical office, that hospital, that laboratory, whatever the case may be, that nursing home. So we are responsible. Employer may not have done anything wrong, yet still be liable. Oh, how are we going to answer this? I already gave you the answer, because everybody in the workplace is responsible, is liable for all the things that they do in that office. So let's put it this way. Let me give you an example. You're a medical assistant, you did something to the patient that you shouldn't be doing, or you did it wrong. But what is it that you're working for? What is that you're working at? And who you working for? For that doctor, the owner of the office, for that hospital. So the hospital is going to be sued because one of the employees, whether it is a medical assistant, a nurse, a doctor, anyone that works over there did something wrong, the hospital is going to sue as a whole. Someone in there may committed the wrongdoing. So the hospital is going to pay. That's basically what it is. So if the medical assistant gets sued, the doctor gets sued, the hospital gets sued. That's how it works. So that's why sometimes the doctor might say, well, I didn't do anything wrong. But your employee did it. And your employee is under you, under your supervision. So you're responsible for it. And we're going to get to that because that's going to be a question for your exam. There is a term that we're going to use. It's a medical term that is going to be used to describe that the doctor is responsible for the wrongdoings of his, her employees. When we're talking about a doctor's office, a hospital is responsible for the wrongdoing of its employees. That's basically what it is. So you as the hospital, probably the CEO has nothing to do with the wrongdoing, but your employees did it. So for that reason, you get sued. That's what it says, who's liable and why is it that a doctor who didn't do anything wrong, but their employees did it, you pay for it too. That's how it works because we are under the supervision of this person. We are the subordinate employees. So this doctor is responsible for it. Let's talk about claims. Remember, these are the documents that we send for services provided to the insurance, of course. So claims made insurance, we're probably going to be discussing this in insurance, but because this is a legal issue, it's brought up right here with medical law and ethics. You shouldn't be worried for medical law and ethics being asking this, but it was included within the chapter and it is part of it. So, and it's interesting because if you work in the administrative part, then I want you to make sure that you do understand how this applies to you as well, if you are working in the administrative part of the office. So claims made insurance. So this is the claims that we are responsible, that insurance is responsible to pay for the services of the patient during the time of the insurance coverage. So every single time that I'm talking to you, I'm always been telling you, when a patient comes in, you're going to verify insurance coverage. Every single time a patient comes to your office and you're in the front desk, your responsibility is, it doesn't matter how many times the patient have come to the office. The patient comes in today. Hi, good morning. My name is Alberto. I'm the medical assistant. How can I assist you today? Oh, I'm Mr. and Mrs. Smith. I'm here because I want to see the doctor. Sure, not a problem. Have you been here before? Sure, I'm an established patient. No problem. Can I have your insurance, please? Oh, I was here 2 days ago. I understand that. But every single time that you come to the office, we need to verify your insurance, okay? Insurance services coverage can stop at any time. And here's the problem. If the patient comes to the office, we do a procedure, we do an evaluation. Just the fact that the patient is being seen by the doctor, we have to charge for those services. So if the patient comes to that day and the patient does not have insurance coverage, the insurance is not going to pay for those services. Period. That is it. So this is important for you because your job is to check for insurance eligibility and coverage for the particular visit. Because if the patient didn't have insurance on that particular day that received the services, we're not going to get paid for the insurance. So who has to pay for the services? The patient. And the patient is not going to pay because the patient is going to tell you now, hey, I have insurance. You didn't tell me that I didn't have no insurance. Oh, but remember that I asked you during insurance. You say, oh, it was a couple of days ago here, and you didn't want to present to me your insurance. So now that's the problem. No, that was your job. You shouldn't have insist. That's your job. Now I'm not going to pay. Now, how are you going to respond to the doctor? You're going to tell the doctor, oh, well, the patient didn't want to show me the insurance. So for that reason, I just let it pass because I thought the patient has insurance coverage. No, every single time that your patient comes in, you check for insurance. Otherwise, we're not going to get paid for that particular day, visit, procedure, whatever we do to the patient. And that's what is called claims-made insurance. Again, now the patient is responsible, the patient is not going to pay. Now it's going to fall on you. Now you're going to have problems with the medical doctor for not doing your job. So we need to understand this. Now, there is another issue with insurance, occurrence insurance. Now, this is when the insurance covers the problem, but based on the time that the problem or the incident occurred. That's basically what it is. Remember, claims-made insurance means that patient came to the office, you did the procedure, the patient did not pay, the insurance did not pay for the procedure. Now this lays on, falls on the patient, and the patient is not going to pay. We have a problem. This one is like the patient comes in today. The patient didn't have coverage today, but the procedure was done prior. So if the procedure is done when the patient was insured, but now the patient doesn't have insurance coverage, it doesn't matter because it happens at the time that the incident or the situation happens. So that's basically what it is. So let's say that you lost your insurance, right? But then something happened prior to losing your insurance coverage. The insurance is going to be responsible for it if you have this clause, occurrence insurance. So that's basically what it is. So we will see this during insurance, because we're going to talk about insurance, but this is for the purpose of you being in the front desk requesting for the insurance, the health insurance card. Remember, you have to ask for this card every single time that the patient comes into the office, regardless of how many times the patient has come to the office. If the patient is being in the office every day, you're going to check for insurance. Many insurances allows the patient certain amount of visits and procedures per period. So it's in 6 months, you only can have one X-ray. Now you come 10 times to the office in 6 months and you want a second X-ray, so you already have one. You're not going to get the second one. And if you get one, you're going to pay for it because the insurance is not going to cover. You get so many times of visits within the doctor. So, or with the doctor, within the doctor's office. So you have certain amount, you have limitations in certain insurances. So for that reason, if the patient goes beyond this number of visits to the medical doctor, the insurance is not going to pay for it. So even though if the insurance is active, still you have a limitation for the number of visits. You have the limitation for the number of procedures. So you have to look through all that if you are in the front desk. You don't have to be billed or coded. It's just that you have to verify the insurance every single time that the patient comes into your office. Any questions about these claims made insurance, occurrence insurance, or promise of cure, a law of agency, who's liable? Particularly who's liable. You need to know that everybody in the office, anybody who works in the office is liable for any wrongdoing. And the hospital, the clinic, the medical doctor, he's the owner of the place, they're going to be responsible. They're going to be also penalized for it. malpractice insurance. Now, again, it's not because we're talking about insurance, because this is a legal issue. So malpractice insurance is the insurance that covers for the services of the medical providers. Everybody needs to have malpractice insurance. Now, medical assistants are not required to have malpractice insurance. Why? It's not that you are required to buy your own malpractice insurance. Let me get this straight, because when you're going to start looking for a job, a doctor might tell you, it doesn't happen often. But if a doctor tell you, oh, you know what? I hire you in this job. I'm going to give you the job as a medical assistant, but I'm not going to provide you with malpractice insurance. It's not that he's going to buy a medical malpractice insurance for you. No, he is going to add you to the malpractice that they have. If a medical doctor tells you that you need your own malpractice insurance, you better run away from this place, because this doctor is a problem. And that's what they want you to have, your own malpractice insurance. Me as a medical doctor, I have malpractice insurance. When I was practicing, I didn't pay for it. I work for a hospital, so the hospital pays for it. So you will be covered as a medical assistant in any settings of the medical field. You will be covered by your medical doctor. So don't believe that stuff that somebody tell you, oh, you have to get your own malpractice. That is not okay. So if that's the case, you just tell them, oh, I was under the assumption that I will be under the malpractice of the practice or the office or the medical doctor or the hospital. Hospitals will never tell you this. So in a hospital, you will not have someone at the hiring or the HR department telling you, okay, we're gonna give you the job. You are hired as a medical assistant, but you are going to get your own malpractice. They will not tell you that. I work in hospitals. I know how it is. I work with doctors' offices. I know how it is. And I know a little bit about this because, well, I was in the medical for a long time. So don't believe any of this, because you will be covered. So you are covered. Just because you don't have your own malpractice insurance, you will be covered. But I heard some cases in which certain doctors require their medical assistants to get their own malpractice. So I do not recommend you to do that, because number one, it's very expensive. So I don't even know how much, but I'm talking about maybe $10,000 to $15,000 per year. We don't even buy our own medical insurance, and you're gonna pay for malpractice. So no, that will be because you are not the person who's gonna do all these heavy or very complex procedures. You're gonna be assistant. That's it. You're not supposed to administer medication, so you're not gonna be in a real trouble. So you're gonna be drawing blood, you're gonna be doing electrocardiograms, very simple procedure. That's not gonna cause the patient to get into any injury. So that's the reason why you will not require to get that. So that's what's important. So medical doctors, hospitals, clinics, they have malpractice, and the employees, they are under that malpractice. Doctors' offices, they will not require. But if you have someone who do so, remember, you're gonna walk away. So that's basically what it is. It says right there, all licensed and certified professionals should carry malpractice insurance. Well, not for medical assistants, not for the nurses. So again, usually it doesn't happen that way. It says an expensive type of insurance. Of course, it's very expensive. For medical doctors, it's 25, 50,000, depends on the specialty. So again, just for you to know, you are not required to buy insurance. The books can say anything, but that's not the law. The books just said this because they just want to cover themselves, saying, okay, every single professional should have a malpractice license. No, because it depends of, the extent and the complexity of your tasks, your training. You are not in that category of risk. So there is no need for malpractice. Remember, malpractice is that you did something wrong, nothing else. So that's not going to be required because you are going to be working under the doctors, the clinic, the hospitals, malpractice insurance. Any questions about this? Okay, so let's talk about these lawsuits. Remember, when you have a lawsuit, then you have to hire an attorney, and the defendant is going to hire an attorney, the plaintiff is going to hire an attorney, and in between the attorneys, they're going to discuss the case. And then if there is merits to go to court, then you go to court, and the jury decides what's going on. Sometimes these cases do not reach that level. Sometimes they have a common agreement that is called an alternative dispute resolution. So this is when you settle the dispute, the lawsuit, whatever case that comes against the hospital or the medical practitioner, that you are going to, talk it out and try to fix it in between themselves. That's basically what it is. There are two types that are more common. Alternative dispute resolutions are arbitration and mediation. So if you have a question in your exam, your national exam, you will be asked, what is the way of settling a dispute, a case, a malpractice case out of the court call? So then you can choose either or. You can choose arbitration or mediation. They're not going to ask you what is an arbitrator or what is an arbitration situation. What is mediation? But the only thing that you need to know is that this is a case that is not going to court. It's going to be being settled out of court. So the attorney for the defendant, the attorney for the plaintiff, they get together and they said, you know what, let's get common ground. We don't have a case right here. So let's talk about money. So we don't want to go through attorneys, to time consuming, all these things, legal issues. So my client wants $10,000. My client wants $5,000. Then the other, that is the plaintiff's attorney. So the plaintiff's, or the defendant attorney is going to say, listen, there is no case, but I don't want to go through all these. Let's talk it out. I'm not going to give you $10,000. I'm going to give you $5,000. Take it or leave it because we're going to settle like that. Otherwise, we're going to continue with this. So that is arbitration. They have someone the decision. It can be an attorney, can be a judge. Someone is going to say, hey, and this person is going to be dealing with the side, both sides. Okay, common agreement, decide what you guys going to do, deal into yourselves, let me know, and I decide for each end. Think about those soccer games or football games that we have someone who is the referee. That's an arbitrator. That's the one that controls what's going on with each team and penalizes whoever commits the fault. So that is basically what it is. I said, listen, let's get from this doctor $10,000. No, but they're not gonna pay. We can settle for 5, for 7, for 8. Well, you start bargaining right there. That's arbitration. Mediation, you're gonna get a third person. You're gonna get someone who's gonna be in the middle, but this person is in no one side. Remember, in an arbitration, you take sides. Well, you're not supposed to, but in this case, you take sides because you are going towards your client. So my attorney is gonna be doing something on my favor, and your attorney is gonna try to get something in your favor. So they kind of meeting, midway. Mediation is none of those. We don't have an attorney from each side. No, we're gonna get someone in the middle. It's not from your side, it's not from my side. They're gonna see the case and they're gonna say, you know what? I decide that you guys should pay this, or there is nothing here to deal with. And you gotta go by what they said. This is not a back and forth situation. This is not the plaintiffs and the defendant's attorney try to negotiate. There's no negotiation here. Someone is gonna be the mediator, someone in the middle who is not from either side, and is gonna say, hey, this is what we're gonna do. After I saw the case, there's nothing here you can do. If you wanna be nice with these people, just give them something so, they can call it a day. But if I decide there is nothing, listen, there's no case. Don't waste your time. You're not gonna win. Or, you know what? There are probably chances that these people bring something out. You know what? Just keep these guys something so you can keep them quiet. The case is dismissed. No more problems. So that's how these alternative dispute resolutions works. Remember, you don't use the court. So that's the part that you need to understand. When the court is not involved during arbitration, mediation, then it's settling the case, the dispute out of court. So that's how you're gonna answer the question. That's what you're gonna look for when you encounter these questions. That's the reason why I'm bringing all this up, because it's about your exams. This is not gonna be asked when you are working in your workplace. Okay, so tell me what is fraud? What is this? They're not gonna ask you any of those questions, but you're gonna know certain things that you shouldn't do in your workplace because it's gonna get you in trouble, it's gonna get your boss in trouble. Role of supervisor. Now, the supervisor is someone who is in charge of these particular, staff members within your organization. So they are responsible for you. So if they assign you some tasks and you don't do it, assigning tasks means delegation. You're gonna delegate some functions. So me as a supervisor, I'm gonna delegate my co-workers because I have a higher rank, so I'm being given, this position so I can delegate. So you today, you're gonna work in the front, you're gonna be working on the back, you're gonna be doing the filing, you're gonna be doing the laboratory. So I'm gonna delegate the functions of the people that is working there. Remember, always make sure that you do everything that it is under the scope of your duty, because you're gonna protect your license. You're gonna protect your certificate. Just because the doctor is asking me to do something does not imply that I have to do it. No, first I have to see is whatever the doctor asking me to do is within my scope of duty or not. And if it's not, you have to refuse. But you have to refuse in a very professional way. You can't say, hey, I'm not gonna do that. I'm not stupid. Why? You're gonna get me in trouble or what? You should know better than me. This is not the way that you're gonna respond your supervisor, your doctor, someone who's asking you to do something. You're just gonna be very professional and you're gonna say, well, as much as I would love to do that, but I cannot do it according to my scope of duty. That's it. You are demonstrating that you know your professional limitations, that you know what you're supposed to do within your scope of duty. Why? Because if I respond with an attitude, I can get fired. That is called insubordination. I can accuse you of insubordination. Is the attitude, the way that you are talking, replying back to me after I gave you an order. Yes, you're not supposed to be doing that, but that's not the way that you should respond back to me. You should be very professional. So you're not being dismissed. You're not being retaliated because you just refuse to do it. It's because the approach that you have, the attitude that you have towards your superiors. I'm telling you that I have experienced all that. I have to dismiss people because of that. And then they try to bring it back, saying that that was retaliation, that that was not fair, that I was speaking on them. No, that's not the way it is. It's because the way that you present yourself during the situation. So you're not being professional. I can ask you to do anything, but you don't have to respond in that way. You have to be very professional. Oh, wow, I'm not stupid. What do you think I am? I know what you're thinking. Probably you want to get me in trouble. Probably you want to fire me, and the only way that you can do it is doing, no. That's not how it works. Oh, I'm not going to do it. It doesn't matter. Whatever you say, but I'm not going to do it. That is refusing to do a job. That is called insubordination. And I can terminate your job for that reason. But if you respond in a professional way, nothing is going to happen. The doctor or the supervisor is not going to get upset. They're going to understand because you're telling them up front that that's not part of your duties. So for that reason, you're refusing to do it, because if you do it, you might get them in trouble, and you don't want to do that. Oh, I'm doing you a favor. So what are you taking it against me? So they're not going to take it against you. It have happened to me. I was a medical assistant because before I became a doctor, I was a medical assistant for 4 years. I learned all this. I was asked to do a lot of stuff that I wasn't supposed to be doing. And guess what? I didn't do it. First of all, because you're not going to pay me more for doing more. My job title is not going to change. I'm a freaking medical assistant. That's it. And you asking me to do the nurse's job. No, I'm not going to do it. But I didn't tell that. I said, well, I don't know how to do that, but if you train me, well, you want something to be done right away. How are you going to be training me? If I have to train you, I just do it myself. The doctor said that. I thought you knew that. I said, no, because that's not part of my scope of duty. So if you want to train me, I would love to, because I want to learn more stuff. See how this doctor is going to take it against me? Not at all. On the contrary, they like me. They count on me. They was like, okay, Alberto, can you do this for us? And I was like, sure, if I can do it, I do it. Otherwise, you know what I did? I said, you know what? I don't know how to do that. It's not something that I was trained during my program, but you know what? I know who can do it, who has the training for that. So I'm going to replace them doing whatever they're doing, and they can do whatever you need. So we just switch places. I'm going to do whatever she's doing, and I can do whatever she was doing. What about that? You always try to look for solutions to get the job done, not to look for conflict, because that's what's going to get you in trouble. See, not knowing how to do things is not going to get you in trouble. It's doing it and doing it wrong, and not asking how to do them, or not practicing just because you don't want to look bad. If I don't know how to do something, I just say, no, I don't. But if you show me, if you train me, I'm definitely going to learn because I'm here to learn. So you're not going to get in trouble for that. So ask every single time that you don't know how to do something. But don't refuse in a negative way. Don't be aggressive. Any questions? Working in a high risk areas. Now, everywhere in your workplace probably is going to be a high risk area. Why? Depends on the job, depends on the responsibility of the job that you are performing. That's basically what it is. And it exists in every single industry, not just medical, anywhere. So how to recognize these high risk areas and how to protect yourself from falling into one of these situations. Medications errors. Now, one of the good things about you don't have to give medications. So no worry about this. But we're talking about the nurses, we're talking about the medical doctors. Because giving the wrong medication, bad. Giving the right medication to the wrong patient is just as bad as the one that I mentioned already. Failure to monitor a patient, really bad. You've been in charge monitoring this patient continuously, blood pressure, oxygen levels, heart rate, but you're not monitoring the patient and something happens, that's a high risk for you. Failure to follow proper chain of command. That falls into that administrative part. Remember, chain of command means to who do I have to complain to if something happens? Should I go to, if I'm a medical assistant, who should I talk to if something goes wrong or a problem arises, something that I cannot solve, something that I need to ask, something that I need to learn? Who should I go to? Your office manager. If there is no office manager, who else should I go to? The nurse. So that is the chain of command. Who am I going to go first? And second, if that does not solve, if the nurse or the office manager doesn't solve the problem, where should I move next? Oh, to the supervisor. Who's the supervisor? The nurse. Okay, let's go there and see how we can solve this issue. And if the nurse doesn't solve it, who else should I go to? Oh, probably the medical doctor. And so on and so forth. You should not jump from, okay, I'm not going to talk to the office manager. I don't get along with them anyways. I don't like him. Or they're not going to help me. I'm not going to talk to that nurse either because I don't like them. They have an attitude. They're a problem. They think that better than me. We will have a lot of issues, right? So I'm going to jump directly to the doctor. Well, you should not do that. You should follow the chain of command. If you have to go to the HR, the human resources, to complain about something, and that's what you have to do, you go there. But if you have to go before that, follow this chain of command, you have to do it. Otherwise, you can lose your job because you're not following the chain of command. Probably this person easily could solve your problem before you jump to the next level or to the next level. So again, lack of communication, for example, abnormal test results. That's serious. Or the medical provider, someone who was in charge, who was delegated to give the results to the patient, didn't do it. Or they call you from the laboratory, gave you the results. They are, red flag results. When they said red flag results means they are bad. So the laboratory calls you and verbally they're going to tell you, hey, lab results from this patient, this lab, this particular lab, this particular analysis came high, extremely high. This is a red flag. Let your doctor know. If you fail to do that, you're in trouble because this patient needs to be called immediately and address the situation by the doctor. But you fail to communicate these abnormal test results to the doctor, so the doctor didn't call the patient. The patient got sicker. Now we are in trouble. Again, or just the doctor didn't give the results to the patient. I work with a lot of people and I have a lot of stories to tell. So I have one of the doctors that I'm working with. He was seeing patients as usual. That's what doctors do, but it was not an emergency. And he has a patient ordered some type of biopsy to the patient. The biopsy results came, they were positive for cancer. The patient did not, the doctor thoroughly forgot about the results. The medical assistant filed the results in the medical record, in the paper-based medical record. That was at that time. Then the patient ended up in the emergency. When they evaluate the patient, they told the patient that she had cancer and it was advanced already. This problem has caught on time. She probably have had more chances to survive. So here we go. It was unintentional. That was not my colleague, intention to harm this patient, but it was not focusing on the things that they were doing. And the medical assistant didn't assess much because before you actually file these test results in the medical chart, it has to be signed by the doctor that they review it and they contacted the patient, whether negative or positive, so that, the due diligence was done correctly, but it didn't happen that way. So remember, we work as a part of the team. I don't know if I told my other students, because I have new students in this class, that when I was working in the emergency, I prescribe medication to my patient, but it's the emergency. I didn't know everything that's going on with the patient. So when I gave, the order to the nurse to give the medication to the patient, the nurse came back to me and he says, "Oh, Dr. Hoyer, you prescribed this medication, but the patient is allergic to this medication." I said, "Oh, seriously? Oh, let me check. Oh, no, let's do something else." But if the nurse was nice to me, if the nurse wants, to cause me some trouble, but at the same token cause trouble to the patient, she probably has dismissed this, omit the information, just give it to the patient and get me in trouble and get the patient in trouble. No, we have to work as a part of the team. When you notice something out of the ordinary, something like it doesn't match, it doesn't work, something that is kind of confusing, don't do it. Clarify this. So she went up to me and said that, and I'm forever grateful. I was new there. That was like my first or second year. So that's something that if it wasn't because we are working as part of the team, we are very busy in the emergency. And I'm running here and there, and I didn't have all the information. Patients in the emergency, we don't have a medical record from them. We create a new medical record for them. And the patient, when I saw the history that they took from the patient, I didn't see anything about allergies. But the nurse have that information somewhere, maybe in her computer when they do the triage. I never bothered to ask how did she found out because I didn't see that, because I don't like to argue about these things. I was just grateful that she caught that situation and that we were able to change the medication before the medication was administered to the patient, probably have caused some harm, serious issue. So when it comes to all these things, you have to be aware and, and making sure that you are, on top of everything. You have to make sure that you are focusing on whatever you're doing. It doesn't matter how stressful your job is. You just need to make sure that every single patient is a different situation. And we have to kind of focus on them every single time. It doesn't matter how busy we are. And that's what we work as a part of the team. That's why we delegate functions. See, if I was the one who was giving the medication to the patient, probably have given the patient medication that it was going to be, causing patient harm or maybe detrimental to my patient. Things happens. We are humans. But if you will work as a part of the team, we can prevent a lot of stuff. So again, it's just the little things here and there. You might be exposed to it. So medical assistants very rarely get sued, I'm telling you, for these type of situations because they don't have as, their tasks doing much of this. But just for you to know. Any questions? Malpractice prevention. So how you are going to prevent this? Well, we have tons of guidelines over there, general guidelines. First of all, you have to work always in the defensive way, thinking about safety all the time. Rechecking twice. I always tell patients, I always tell my students, verify things twice. Sometimes sounds obvious, verify twice. You're having a patient who you've been ordered to do blood work. Verify that you have the right patient, that this is the patient that it was ordered to do the procedure. Remember, sometimes we are caught up in the midst of all these hefty days, craziness going around, and we got very stressed out. So we don't check. We just want to do things. Okay, next. No. You got to take a little time and verify that you have the right patient to do the blood, to do the electrocardiogram, to do the vital signs. Mixed up blood results are a very serious situation, and you don't want to be there. So always think about the safety of your safety, because your certification, your licenses on the line if you don't do things like that. Communication. If you're going to do something good, communicate effectively with your patients. Listen to your patients. We went through this. We have a chapter already of communication. Communicating effectively to your patients, listening to the patient, whatever they have complaints, anything. Because if you do not communicate with your patients, then you are not being a good practitioner. You are dismissing their concerns. You have to be willing to listen to your patients to find out. I listen to my patient. How do I know what's actually going on with them? What are the symptoms? What is the problem in general? Documentation. Everything that we discuss with the patient has to be documented. Not on a piece of paper, not on a post-it, no. It has to be documented within the medical records. There is a phone for all the communications. There is a phone for the nurses. There is a phone for medical assistant. There is a phone for the medical doctors where they need to document all the information that they collect from the patients. We have spaces within medical forms to document things that pertains to the patient, like vital signs. So we need like appointments, cancellations, no shows. So we need to do all these continuously and get familiar with that and learn exactly where do we have to document all these. Communication, if you are nice to your patients, chances are that they will not suit you. Believe me, they will not suit you. I know cases where I have my colleagues not being sued after they actually committed some bad malpractice. But they were really nice to the patients. When the patients were there, they were taking care of them. They were very pleasant. They gave sample medications when they didn't have insurance that covers for those medications. Something happened to the patient because the medical doctor forgot something. They didn't do this procedure. They didn't order this medication. The patient got worse, but they never sued the hospital. They never sued the medical doctor. Why? Because the medical doctor was there whenever the patient needed. Patient without appointment showed up and have this, have that. The doctor was there to help them. They didn't sue him. So again, things happen. But when you're rude, you're not nice, I'm just waiting you for a little something. And I'm gonna get you. Because that's what's happened. Payback time, they're gonna tell you. Oh, you weren't nice to me. When I came here, you ignored me. I told you about my problem. You said, oh, next time we discuss that. That's not serious for now. Oh, we don't have time right now to discuss that. Make another appointment. Well, guess what? When you get in trouble, they're not gonna be there for you. They're gonna be against you. So that's basically what it is. So documentation, documentation, documentation. There is an old saying in medicine about documentation. If you didn't document it, you didn't do it, it didn't happen. So you have to document everything. Because remember, in the court of law, this is the only valid thing that can save the doctors. Not gonna save the world, but it's the only thing that can save us. Documentation. It was documented, it was right documented, it was legible. That's our best defense, documentation. But if you didn't document it correctly, you didn't communicate with the patient, you didn't get all the information necessary for the diagnosis of the patient, everything is going to be documented because whatever you ask the patient is going to be written there. If you didn't ask and you were supposed to ask, remember, you failing to do it, nonfeasance, wrongdoing, tort, negligence. They're gonna come after you. So that's basically what it is. Any questions about all these? Okay, so let's move on because we still have 2 more chapters to cover. Tomorrow is the 13th. Tomorrow is the last day of class, remember, for this module. So no worries, I'm gonna be just fine with this. Let's gonna talk about this, some stuff right here. This is like most of the things overlaps, but this is chapter 4. It was supposed to be before, but I have a lot of things that it was discussed already. The first lesson, the third lesson, So we're going to talk about this. Legal and ethical aspects are in the healthcare. So we talk about medical practice acts. Remember, these are the statutes, these organizations that, are monitoring the licensing of all the practitioners. That's basically what it is. So who is credentialed in what? When we talk about credentials, we're talking about what certificates, what licenses you have. So these organizations are the ones that licenses you, that remove your license, that requires you to take an exam, that requires you to practice these particular tasks, what you're supposed to, we're not supposed to. So that's basically what it is. We covered this. Now, let's talk about these licensures, because this is very important, not to see how often the medical doctor has to renew their license, because that doesn't pertain to you. We don't care about that. But how do we kind of obtain this license or certificates? So it goes for you too. You're gonna have a non-license, you're gonna earn a certificate. So let's talk about these two things, because these are the most important ones. And one of the things that I want you to learn right here is, because it is a question for your exam, is reciprocity. This is something that I do want you to understand for any professions, any titles, if you will. So if you have a question when they ask you, what is reciprocity? Or when you transfer your license from one state to another state, then you have reciprocity. So you, as a medical assistant, you have reciprocity with all the states in America, in North America, because there are 3 Americas actually. So in America, you have reciprocity. What it means is that if you take your certificate here in New York, you move to Florida for any reason, you can apply for a job over there, you don't have to get another license, another certificate. You are going to be accepted regardless where you get it. So that's basically what it is. With license are not well, let's rewind. Licenses are state, is federal, state license, meaning the state where you got your license, that's the state where you need to work. Certificates, you can work everywhere within the 51 states of this country. Now, reciprocity, once again, if my license here in New York, I got my license here in New York, so let's say that I want to move to Florida. If Florida doesn't have reciprocity, meaning they don't have any agreements with the New York State Department of Education, they said, oh, well, if you move here for a job to Florida, you have to take an exam, okay? Just take an exam like the first time when I graduate from university. So I have to take that exam. Oh, no, I almost failed that exam the first time. I'm not going to take it again. No, that's too much. No, I'm not taking that job. Then I go to Connecticut and I said, oh, I got a very nice offer over there. It says, hey, what are the requirements for me to move over there to work with you guys? It says, no, we have reciprocity with you guys. So Connecticut, New Jersey, I believe Pennsylvania, we have reciprocity, meaning I can use my license over there, go work over there, go live over there, and I don't need to take a test for this. So the reason that I'm giving you this is because you're going to have it in your exam. So if you have it in your exam, they're going to ask you, okay, when one license can be transferred to another state without taking an exam, what is called that? So then you're gonna be calling, oh, that's called reciprocity. When one license is accepted in another state without going through any paperwork, any registration, any exam, what is called reciprocity. Meaning they accept your license from your state without going through anything. They're just gonna register you as a medical doctor over there, but that's not gonna cost anything. That's done by the hospital that's hiring you. That's it. Anything else? No worries. We're gonna talk about this in pharmacology, so no worries about this. This one, yes. Physicians responsible for actions of employees. Remember, we talked about on the prior chapter that, even though if the doctor is not the one who committed the negligence or the malpractice, but was one of his employees, you're gonna pay for it. That's based on this particular issue. It's called respondent superior. Respondent superior. Write it down, put a mark over there because you need to know this when you're taking your exam. So they're gonna ask you either or. What is a respondent superior? Then your answer, remember, respondent superior. Your superior has to respond for the faults, for the wrongdoings that you did. It's your superior, your boss. That's how I see it. So I kind of moved these words. I kind of switched them up. Respondent superior. Oh, your superior has to respond for you. So when your superior is liable, it has to pay the consequences for your acts. Is called respondent superior. Is that understood? So remember this. Remember the RIPSA loquitur? Also, things speak for itself. This is important. Something was left on the patients after the surgical procedure. What do we call this? So again, you need to remember those terms because they will be asked on your exam. So that's the reason why I'm going over this, not everything else. Nobody's gonna ask you how many credits do the medical doctor has to have in order to renew the license, how often they renew the license, not at all. So here it is. Remember what I already told you, certificates. One of the things that you need to understand that your certificates are voluntary. This is good for your knowledge because you need to know whether you want to take the national exam or not. Every single that I teach my students, I go over this every single time. So the difference between licensings and certificates is not that licensings are state-wise and certificates are nationwide. This is not the only difference. The difference is that a licensed person must take the state boards in order for that person to become the practitioner that they study for. A nurse. If you are a nurse and you finish your coursework in this particular college, university, with that certification of completion, you cannot work as a nurse. That is not a way of getting your job. You have to take the board. You have to take the NCLEX test, which is state test. And if you don't pass that test or you don't take that test, you're not a nurse. You cannot practice as a nurse. Whereas medical assistants, you graduate from this school that you are now, the school is going to give you a certification of completion, meaning you completed all the courses, all the modules, you passed all the tests, you did your internship, you passed everything. You can work with that certificate of completion. You can go and look for a job with the certificate that the school gave you just to complete these classes. See the difference? That's what it said is voluntary. If you want to take the national exam, it is up to you if you want it. Now, this is the catch. You're only going to be able to get jobs with the certificate of completion from the school if you work in a doctor's office. If you apply to work in a hospital, in a private laboratory, if you don't have a national certification, you will not get the job. See, that's what is important to take the national certification exam, because hospitals is the place where you're going to get all the perks. You're going to get high salary. You're going to get vacation, paid vacation, sick days, holidays, overtime if you work overtime pay, medical health insurance. Hello. Probably if the hospital has union, you're going to get tuition reimbursement. Medical doctors are not going to give you any of this. Medical doctors only going to pay you salary. That is the lowest. And that is it. So you have more opportunities getting the national certificate. Okay. So again, because this is going to come one day that you are going to be completing this course and you're going to be saying, oh, what should I do? Should I get? What if I don't pass? If you don't pass the first time, which I know you will, you're going to pass. Then the first time, then let's say that for some reason you didn't pass. No problem. You can take it again and again and again. You just have to pay every single time that you register to take this. But to be honest with you, you should pass the first time, because first of all, I've been giving you almost every single question for each chapter. So how are you not going to pass? So I'm pretty sure that you will, believe me. Okay, so that will be credentialing. Remember, credentialing means all your certificates, what you qualify for. So that's basically what it is. Anything else, do not worry, because I've been talking to that a lot. License revocation or suspension. So why a doctor should lose their license? What are the reasons why someone felony? If you commit a felony, remember, what's a felony? Felony. What am I saying? It is a serious crime. It is a crime that is punished for more than 1 year of prison. That's a felony, because we have misdemeanor. Misdemeanor is a minor. It's like a minor. And usually is punished with less than 1 year prison or probation or a fine. So felony is very serious. For instance, you were accused of rape, murder, some fraud cases, fraud with Medicaid, Medicare. Not good, because this is the government insurances. So you are going to lose your job, lose your license. So basically what it is. If you are using alcohol or drugs as a medical professional, you're disqualified. So your license will be suspended or, worst case scenario, revoked. If you are incapacitated, you have a medical condition, you have a mental problem, or you develop Alzheimer's disease. So remember, Alzheimer's disease is when you forget things. Your mind is not there. You don't remember anything. How are you going to be taking care of your patients if you don't remember anything? So then you will not be able to perform as a medical professional. Not because you are old, it's because you have this condition. So it is like a very advanced dementia. Not good. So before we call it the night, because remember, we're going to finish at 9, we're going to go over the contract. We already talked about the contract, but now we're going to talk about the pieces, the items that are needed to have a contract. Remember, we have the 4 deeds of a lawsuit: duty, the relation, the injury, the damage, and the direct cause, remember. So we have to have all of them to meet the criteria. In order for us to have a contract, it has to meet this criteria too. So when the doctor contracts with the patient, the doctor is offering a job, a service. I'm offering, my clinic is offering, I'm a doctor, we're a hospital, we're offering services for patients. We offer, the patient accepts. Now we have a relation, patient, physicians, patient relationship. Now, remember that I mentioned that if we have this type of relationship, has to be compensated. So it's got to be some type of valid consideration. That's what it's called. Compensation is called consideration. It has to be valid. So you're going to pay me or the insurance or whatever the case may be, but I'm going to get paid. Cash, check, debit, credit, through your insurance. That's how we get paid, because if you don't have health insurance, then we take other methods of payment. So that is consideration. That will be number 2. Now, this contract has to be lawful. What do you mean lawful? I don't get it. Well, that this contract, whatever I'm going to offer you, is within, the requirements of law. This is legal. This is not something illegal. We're not going to make a contract. And see, drug dealers don't make a written contract. Hey, I'm going to give you this, you're going to give me that, you're going to pay me this much. I don't care what you're going to pay me, how, but this is it, sign right here. No, it's not happening, right? Or you're selling some illegal drugs, it's not going to happen. So you're not going to have a contract. So then it has to be lawful, meaning it has to be within containments of law. Number 4, competent parties. Well, the person that you are signing the contract with or you're contracting with has to be mentally capacitated. So that's basically what it is. So they have to be able to make decisions for themselves. So can you contract with a drug abuser? No. With an alcoholic? No. We don't make contracts with these people like that. Why? Because they are not mentally capacitated. They are not mentally competent. Can we do it with a minor? No. Because the law does not accept a minor to get into contracts. A minor cannot rent an apartment. A minor cannot buy a car. A minor cannot do a lot of stuff. So how can you do it? So it has to be competent. The person has to make their own decisions, but it's an adult and it is a right state of mind. So right is, that's the way it is. So you have to meet all the requirements by law because it has to be lawful. So that's basically what it is. So you have to meet all those things. So one of the things that usually comes on exams is what is consideration. Number 2, you need to know what's consideration. Consideration is the method that you use to make the payments. How you're going to compensate the other person for your services. Now, if we talk about the medical, it has to be or money or through the insurance, right? Cash or insurance. So when I'm talking about cash, includes checks, money orders, debits, credit cards, and health insurance. So consideration, when you have a contract, what is consideration in a contract? Oh, the payments, how you're gonna compensate for the services. That's called consideration. Any questions about a contract? Remember, this is the contract in between the patient. And of course, most of the legal contracts should be this way. See, when you rent an apartment, when you buy a car, when you buy something, you sign and you promise to pay for it. Makes sense. And it's legal. It's not something, oh, I'm selling you this car, but it's a car that belongs to me. It's not something that I stole from someone else, because that's illegal. You're not going to be selling something that, well, then it wouldn't be a legal contract. So that's basically it, to be legal. Any questions? Breach of contract. So this is the last slide that we're going to cover. Breach means to break the contract. How we not compliant with the contract. How this contract is no longer valid. Well, from the side of the doctor is if the doctor abandoned the patient. Remember, we talk about abandonment. You're not contacting your patient that is taking medications, and we're not trying to figure out how it's doing after a surgical procedure. The patient missed an appointment. We do not contact them to reschedule. The patient did not show. The patient is not going to the referrals. We're not contacting the patient. Well, that's not our problem. If the patient doesn't want to do it, that's their fault. No, it falls on the practice. That's basically what it is. From the part of the patient is non-compliance. Simple. Non-compliance. What is non-compliance? Patient is not following all the instructions from the doctor. It's not taking the medications. I make appointments. The patient is not showing up. I ask the patient to get this particular procedure. It's not doing it. So if it's not doing it, then the contract is breached. So you're not following what you promise you will do for your patient. You're not following what you promise to do for your physician. You're putting me at the risk because you're not following the things that I'm telling you, so you're not gonna get better. Now you're gonna get in trouble, healthy wise. Now we're gonna end up in the court of law. Now I'm gonna have to use, my skills of assumption of the risk, or that was your fault. You didn't follow what I asked you to do, so that was all you. So what am I gonna go through all these issues? So usually, remember, when the patient is not compliant, well, we are going to dismiss the patient, but we cannot dismiss the patient at once, on the spot. We're gonna tell the patient, okay, Mr. and Mrs. Smith, I already told you this before. We're gonna tell Mr. and Mrs. Smith, I'm very concerned about your health. Your health is very important for me as it is for you, but you're not following my appointments. You're not taking the medication. You're not following my recommendations. You failed to come to the appointments. This, make them sure that you know what it is, because everything is going to be written in a letter. And you're going to give this letter to the patient with 30 days in advance for the moment from the last visit when you are talking to the patient. You got to give the patient 30 days notice. And you have to give by certified letter. Remember, a certified letter requires us to receive